Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. It's good to have you all here with me this morning. We'll start our day in Lansing, Michigan. Tony Flores.
Your Honor, Assistant Public Defender Sarah Donnelly on behalf of the defendant, Jacob Garcia, who is appearing separately by video from the Hingham County Jail.
And sir, you are Jacob Garcia, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Mr. Garcia?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. I've had the opportunity to speak with Mr. Ianni and Ms. Donnelly on this matter. Mr. Ianni, how are we proceeding today?
I believe we're going to have a waiver, Your Honor.
Okay, so we'll waive first and then we can address bond before I lose jurisdiction. How's
Yes.
that? All right. All right, is that a fair statement? This is a waiver with negotiations to continue in circuit court, Ms. Donnelly?
It is.
Okay. May I inquire of Mr. Garcia of his waiver of the preliminary examination?
Yes.
Mr. Garcia, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Sarah Donnelly, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations are going to continue. Is it your wish today to waive your right to a preliminary examination?
Yes, sir.
Do the people also waive their right to a preliminary examination?
Yes, Your Honor.
Okay. I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature purposes. Ms. Donnelly, you can go via, we can have the client sign via Zoom.
I could have gave you a pen. I like my purple. Do I do that or you do that, sir? For a defendant.
You can do it. Yeah, I can do it, but Mr. Garcia, do you give since we're on Zoom, do you give Ms. Donnelly permission to sign on your behalf any documentation for bind over?
Yes, sir.
Okay. Right, I'm in possession of the bind over documentation on 25-0-1114. I'm going to indicate that the examination is waived on today's date, February 20th, 2026. And Ms. Donnelly, did you want to address bond?
Thank you, Your Honor. Yes, as mentioned, we have discussed a bond, a request and amendment. Mr. Ianni can put the conditions that he is requesting that we're agreeing to on the record, but we would be asking that the bond be set at $1,200 cash.
And my understanding, Mr. Ianni, is that this is set pursuant to statute, but there can be a good cause reason for the modification in bond. Any particulars you want to place on the record?
I can explain, Your Honor. The statute in this case establishes a cash bond requirement of 25% of the arrearage, which in Mr. Garcia's case would be a bond of about $3,100. This is substantially less than that. However, the court is allowed to deviate from the statutory requirement where it finds good cause on the record. I would note in this case that Mr. Garcia's history in paying, he had a lapse from about 22 to 25 where he wasn't paying anything. But since the beginning of 2025, he was employed. He was making regular payments up until about October. So any promise that he's provided that he has employment waiting for him doesn't appear to be an empty promise. This does have some history here indicating that he is employable and willing to pay his child support. So if the court were to find good cause in this case, we would ask that these following conditions be imposed. One, any bond that's posted be posted in his name, not in any third party's name. That's so to allow ultimately the bond to be assigned in front of the court's office, if that's part of our agreement for resolution. In addition, there's not to be any contact with the custodial parent. Her name is Amy Milbourne. There's a history here of domestic violence, and Ms. Milbourne has expressed a credible fear. And the final condition is that he does secure employment, make his court-ordered child support payments while he's out, if possible, enter into a wage assignment.
I'll reiterate those for the record, Ms. Donnelly, just so. All right, the request is for modification of bond. There has to be found good cause to modify the bond underneath the 3133 cash bond that has been set pursuant to statute. So the court would look at all the factors, and then Mr. Ianni's indicated that if any bond is modified, it should be posted in his name. No contact between himself and an Amy Milbourne. Is that correct?
Milbourne. Right?
Milbourne. All right. Amy Milbourne. And that's Milborn.
Bourn.
Burn.
Bourn.
Milborn. All right. Thank you. And then if the defendant does secure employment, if possible, any wage assignment would be part of the agreement. Is that your understanding, Ms. Donnelly?
Yes.
All right. And the request today is for $1,200. I find good cause to deviate from the statutory amount, and we'll set the bond at $1,200 with the following conditions. Any bond should be posted in his name, which should be in Jacob Garcia's name. No contact with a Amy Milbourne, and any securement of employment would, if possible, would enter into a wage assignment. And we will set bond at $1,200 cash or surety.
No surety, Your Honor.
Or just cash, $1,200 cash. All right, $1,200 cash, and that should be posted in Mr. Garcia's name.
Yes.
All right, so I will reiterate the $1,200 cash. $1,200 cash. Anything else before I sign the bind over documentation, Mr. Ianni?
No, Your Honor.
Ms. Donnelly?
No, Your Honor.
All right, Mr. Garcia, your time in district court is done. You're off to circuit court. Will you get your next date of appearance in circuit court from your attorney, Ms. Donnelly? All right, sir?
Yes, sir.
All right. That's all for the record in 25-01114. Thank you, everybody, for your appearance today. Thank you, Mr. Ianni. Thank you, Ms. Donnelly.
All right. Give me a call if you get out. When you get out.
Okay. Thank you.
Can you go for a couple? Absolutely. Thank you, bro.
Do we have everybody here for Mr. Berman's PCC?
We don't have Mr. Hodges. Okay, I don't know who that 989 number is.
Let's identify. On the cell phone, 1140. Could you please identify yourself?
My name is Chad Bedell.
Riley Donnelly.
Riley.
Oh.
All right, Mr.
Yeah,
Bedell, we
Riley
have
Donnelly.
you.
Sorry.
All right. All right, Ms. Donnelly, we'll rename you, and you're here on your probable cause conference. Mr. Bedell, you're also here on your probable cause conference.
Is Miss Wanji, is she ready on any of hers?
So, Mr. Bedell, we're going to put you in a breakout room with your attorney, Ms. Donnelly, so you can talk before the probable cause conference. All right, ma'am? All right, sir? All right.
I want to figure out if Ms. Wanji is ready to proceed on her matters or she needs to speak with her client.
All right, Ms. Swanji, do you need to speak with your clients or are you ready to proceed on your matters?
I am ready to proceed on both matters, Your Honor.
All right, so you have Trayshawn Clay and Riley Donnelly, is that correct?
That's correct, Your Honor.
All right, let's go on Trayshawn Clay. So we're on the record in 26-00386. That is People of the State of Michigan versus Trayshawn Clay. Appearances for the record, Ms. Fortuna Gill.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Ms. Swanji.
Good morning, Your Honor. Melanie Biwanji for Mr. Clay.
And sir, you are Trayshawn Clay, is that correct? And you'll have to unmute.
Yes, Your Honor, I'm Trayshawn Clay.
And you can hear me all right, Mr. Clay?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding, or do you like to defer to Ms. Wanji?
Your Honor, at this time, no offer has been conveyed. I do anticipate we will leave this set for preliminary examination.
And is that your understanding, Ms. Wanji?
It is my understanding. That's my understanding, Your Honor.
All right. So let's leave on for the previously set preliminary examination on February 27th at 9 a.m. That is Friday. So next Friday at 9 a.m. So Mr. Clay, that'll be live in person on the 6th floor of City Hall of Lansing. And we'll see you on next Friday at 9 a.m. All right, sir?
Yes, Your Honor.
Anything else for the record in 26-00386, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Nothing for the defense, Your Honor. Thank you.
All right, we'll see you next week at 9 a.m. Thank you for your appearance today, Mr. Clay.
Thank you to Your Honor. You have a good one.
You too.
So you did.
All right, and then we have Ms. Donnelly.
Yes, Your Honor, the believer right on Miss McConnell.
On Mr., are you here on Mr. Williams or?
Williams here.
Okay. And you have Mr. Whiting also. All right. All right, so we're on the record in 26-00373. That is People of the State of Michigan versus Riley Donnelly. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Biwanji for Miss Donnelly.
And ma'am, you are Riley Donnelly, is that correct?
Yes, Your Honor.
All right. And you can hear me all right, Ms. Donnelly?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, no offer has been conveyed. I do anticipate leaving this set for preliminary examination.
All right. And is that your understanding, Ms. Wanji?
Yes, it is my understanding, Your Honor. Thank you.
All right. So we'll leave on for preliminary examination for February 27th at 8:30. February 27th at 8:30. That'll be next Friday at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. All right, Ms. Donnelly?
Yes, Your Honor.
All right. Anything else for the record in 26-00373, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Nothing for the defense, Your Honor. May I have a breakout room with my client, please?
Absolutely. So, Ms. Donnelly, we'll see you here next Friday at 8:30. And then Ms. Wanji, I'll put you in room 2. You should get a prompt to go to room 2. I guess that. Is that
And will
right?
I be able to do that over the phone?
Yeah. We're gonna assign you to room 2.
I believe we are waiting on Ms. Donnelly or I know,
That's Chad Bedell.
yes, and John Williams, which are both, we're waiting on the attorney.
Then let's see, Behrman's here on Hodges.
Yes, I'm just not sure who else is on the Zoom sphere.
I just got an email from Mr. Behrman that Marshall Goldberg is
All right.
on that case.
All right.
That would
So
be me.
Mr. Goldberg, you're here on Robert Hodges, is that correct?
That is correct. I put in an appearance
And
yesterday and sent a substitution of counsel to the defender's office. They said they would file it. I prepared it though.
all right, and then Mr. Behrman's here, and we're waiting Mr. Hodges to be here. Is that or not?
Oh, well, I was expecting him to sign on. If he hasn't signed on yet,
He may be.
Might be the mobile
He
one.
might be the
might
cell
not
phone that we haven't
identify himself.
identified yet.
yeah. I can text him.
All right, friends, once again, good morning. TCF Live on a Friday, a super Friday as we call it here. Why? Because regular Fridays are for losers, and we're winners here. It's good to have you all here. Let's have a great day today, but let's change it up. Lansing, Michigan is still the place to be, but let's head over to Stacia Buchanan's courtroom.
Are you Christian Moon? Today's the date scheduled for a preliminary examination. I also have allegations here of a no contact order violation. Mr. Moon, if you violated the no contact order by direct contact or indirect contact, you could be in contempt of court, which is punishable by up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already faced. You have the right to have an attorney. You already have Mr. Kaplan representing you. You have the right to have a trial at which the prosecutor would have to prove beyond reasonable doubt that you violated a court order. Do you understand the possible penalties? Mr. Kaplan, have you decided what we're doing about the contempt?
We have, Your Honor, would like a hearing.
Yeah. Like, March 6th, 10 a.m. It's my understanding that we're proceeding with the preliminary examination today.
Oh, that's correct, Your Honor.
Are there preliminary matters before we begin taking testimony?
Yes, Ms. Eaton here. I would love to have this marked as 1A through 1J. That is all for preliminary matters for people.
Okay, preliminary matters from you.
Yes, Your Honor, thank you. First, we would like to request
And she just kills her feed for no particular reason. Thanks, Judge. All right. Let's go back to Tony Flores.
To proceed today.
Yes.
I know you don't have. I know you don't have any discovery in this matter. So how did you want to proceed?
Your Honor, first of all, I did prepare a substitution and I was going to file it, but defenders said they would. I'll forward one to the court anyways.
All right, just in case. That's probably not a bad idea.
Secondly, you're correct. I have no discovery. I'm going to ask the court to set it for another probable cause conference so that I can obtain hopefully both paper and digital discovery from the prosecutor.
All right. I don't have any problem setting for probable cause conference. We have a prelim set for next week. Mr. Hodges, did you, and you're just brand new on the case. So I don't have a problem with a good cause adjournment, but the good cause adjournment means that we're going to set it fairly quickly. I'd say like 2 weeks.
Or Judge, could we just set the prelim as a PC?
Okay.
We could that, but he's got no discovery.
Yeah.
So some of it depends on I could set that, I could use that prelim date as a PCC date, but I don't know the volume of discovery.
Your Honor, your dates are always Fridays, I presume, on these?
Thursdays or Fridays, depending on the week, but those are the 2 days.
Okay. Next week, I know I've got a complicated morning. The following week, which would be Thursday the 5th or Friday the 6th, I can set a probable cause conference for either of those days.
Okay, I don't have March, it would be Thursday, March 5th.
That's our prelim day.
That's a prelim day.
Ah.
So it would be Friday, March 6th or Thursday, March 12th. That's the following day, the following week.
We have 6.
Okay.
As it pertains to the 12th, although I gotta be honest, I don't have a plan yet. I am planning a trip for spring break with my son, so the 12th may not work for me.
I can deal with the other date. That's fine.
So the March 6th date will work for you?
That will work for me.
All right, perfect. All right, so I'm going to find good cause to adjourn. And we'll adjourn this for a PCC set on March 6th. And what time is that one?
8:30.
8:30. March 6th at 8:30. That should give some time to get the appearance in and get discovery rolling concerning this matter. So March 6th at 8:30, and we have a good cause adjournment for Mr. Hodges and for the new attorney to get discovery. Anything else for the record in 26-00389, Mr. Behrman?
2 things, Your Honor. We're going to wait then for the 6th to select a preliminary exam date if needed.
Correct. I'll set it right after that, not knowing Mr. Goldberg's schedule. We'll set it,
Okay.
and that will address whether it. At that time, Mr. Goldberg, we may have to address, just because we're moving dates around, whether Mr. Hodges is going to waive his 21-day rule.
I understand, and I'll discuss it with him.
Right.
And if
Anything
the
else, Mr.
assistant
Behrman?
prosecutor could give me his bar number, and I will send him an email.
Yes. My bar number is P54381.
Thank you, sir.
Yes.
Anything else, Mr. Behrman?
Yes, Your Honor. I need to make sure that a signed copy of the substitution gets to my office so that our discovery unit will send it out. Even if there's an apparent sent, they may not, because there's another attorney already on the file. So I need to make sure.
I will send them direct. I'll send the substitution on my own directly to the court. I'll forward my appearance directly to you.
Okay, and then we'll need a substitution signed by Your Honor, and we'll be all good. Thank you, Your Honor. I have nothing
All
further.
right. That's a good idea, just to make sure Mr. Goldberg has discovery. Anything else, Mr. Goldberg, on 26-00389?
No, thank you.
All right. We'll see you. We'll see everybody, and via Zoom is good for that probable cause conference on March 6th, I believe.
Yes.
March 6th. March 6th at 8:30. So, Mr. Hodges, that PCs can be held via Zoom, but the preliminary examination will be live whenever we set it. Anything else for the record? And that's all for the record. 26-00389. Thank you, everybody, for your appearance today.
Thank you, Your Honor.
Morning once again, everybody. TCF Live here on a Super Friday. Good to have you with us today. So I'm going to head down to Fulton County, Georgia. We'll spend a little time with Robert McBurney. Now, he's an entertaining judge to watch, but I don't think I've shown him on the live before. And here's the thing, just a heads up if you haven't heard him before, he eats his microphone. So he's going to sound a little bit like this sometimes, but I've dialed it down about as much as I can, but he's still entertaining to watch. So bear with it, because quite honestly, most of the courts this morning are running like a 2-minute drill, where they're in and out and it's real hard to show them. But McBurney spends time with people. So let's go there and see what's going on.
To understand where we are, the crossroads we're at. We are starting your trial on Monday. There has been a long, long wait for you, for the victim's family, and everyone else. And through no fault of your own, you've cycled through a couple lawyers. This is not a situation. I want to be very clear. I do not view this as a situation, because we get it sometimes, where there's a defendant who, for whatever reason, wants to avoid trial. And so he works with a lawyer for a while, then he fires that lawyer for the only reason being given, like, well, we're not getting along. And that's not your case. You had a lawyer at first who had to take a leave of absence because she was ill, but as far as I could tell, you got along just fine. Then Mr. Johnson, and out of a bad series of coincidences, he became very ill. But everything I had heard was that the two of you got along all right. A couple lawyers pitched in on a temporary basis to keep your case moving forward, but made clear they weren't going to become your permanent lawyer. And then through an effort of your family and these other lawyers, Mr. Banks was brought on board, which was a pleasant surprise to me. He is a private attorney who doesn't handle lots of cases in state court because he's very busy handling very complicated federal cases. And so he's in Florida and elsewhere in Georgia and around the country doing federal cases. But he also handles cases locally, and he stepped forward and filed an entry of appearance on your behalf. And since he's done that, he has been litigating on your behalf very effectively. We have paused the proceedings so that you could get an evaluation. He shared with me, again, protecting confidences with you, some of the steps he's been taking to be as prepared as possible for trial, faced with the evidence that's in this case. And the little bit I've heard from meetings with your lawyers is that there's a lot of evidence that favors the state's case. So it's a complicated case for the defense. That being said, I have no indication that Mr. Banks is anything other than ready to go forward on your behalf. So we need to work through today whether you want him and his associate to represent you starting Monday morning, or if you want to represent yourself. And then technically there's a third option. If you are able to bring a lawyer on board who wouldn't know much about your case, but says, that's all right, I can learn quickly, and is going to be here Monday morning to pick a jury, you can have any lawyer who files an entry of appearance. I don't want to preclude you if there's another lawyer you have in mind that you can afford, and who tells you, I can be ready because I know what the case is about. I don't know that that lawyer exists, but that's not my decision, that's yours. Assuming that cannot happen, then I'm looking at the three people who are possible representatives of you for your trial. Mr. Banks's legal team, that's two, or you representing yourself. And you have that absolute right, and we can have a conversation about that if you want to represent yourself. But otherwise, Mr. Banks and all the work he's been doing is what is going to be representing you on Monday morning. And I thought it was important that we have a face-to-face conversation about that, so you can share with me your concerns. And I did get a letter that you wrote where you indicated you feel Mr. Banks isn't prepared. I don't have that sense from my interactions with him, the motions he's filed, the things he's trying to keep out at trial, certain body cam footage and certain testimony. Those are all, to me, the hallmarks of a lawyer who has dived deep into the evidence and sees where there are things that there's a legal basis to say, let's keep this out because it's prejudicial to my client, and there's a good faith argument to make that this should be excluded. And all this has been happening. So I just talked a whole lot, but I wanted to give you my view, because you shared your view with me in that letter, of how things have been moving forward with your case since Mr. Banks has been involved. We slowed down at his request, which was your request, for some of the work that was done in terms of mitigation and a defense. And we're done with that phase now, and it really is time to move forward. And that's what we're going to do on Monday, assuming it's not a plea. I don't ever want to take that off the table either, but that's a decision for you and your lawyer based on negotiations with the state. So tell me, without going into, I'm not asking you to share private conversations you've had with your lawyers. Tell me where you are right now in your thinking about how you want things to move forward on Monday.
Yes, Your Honor. If I may.
And can you bend the microphone down, and is the light green on there?
No.
Okay, if someone will put his finger in that little well, it should turn green. Great. Yes, sir.
How you doing, Your Honor? If I may state something for the record. So Tanya Miller was my first attorney. My family paid her $50,000. Like you said, she became ill. My family was never refunded or compensated any of that money as she handed my case over to Ted Johnson. Ted had a stroke and could no longer represent me as well. Attorney Banks came on to my case, and we've only met 5 times. I understand that you feel that he's prepared, and I'm not saying he's not prepared, but we haven't had much communication regarding my case. The first time that out of all 3 of my attorneys that I ever laid eyes on the evidence was this past Sunday. We haven't had communication as it relates to a defense, a strategy. I haven't been a part of the defense. There's been a lot of difficulties understanding the facts of the case. There's been a lot of difficulties understanding what has been done on my behalf or for me.
When you say, I don't want you to go into things you've exchanged with your lawyer, but when you say difficulties understanding the facts of the case, give me an example of, you mean like you're not sure what the evidence is, or you're not sure what the state is accusing you of?
I'm not sure of what our defense is, the strategy. I'm not sure of, I just saw evidence on Sunday.
Okay.
So understanding what it means and as far as what our approach is, as far as all of that evidence, as well as there hasn't been any conversation about investigation that has been on my behalf, any things that have been looked into. I know that Tanya had some photographs. I don't believe those photographs have been given to Attorney Banks. There's just a lot of things that haven't really been sufficient. And as it relates to my defense, I'm in the blind. I don't know really what's going on.
I'm gonna push back a little bit on that, and I don't want you to tell me, well, Mr. Banks said this or that, but Mr. Banks and Ms. Willingham and I have had some fairly detailed conversations where he has relayed somewhat indirectly, because he doesn't want to disclose confidential exchanges between you and him, defense theories and work that he was doing and reasons why. Basically had to articulate it because he was asking for more time. And my pushback was, Mr. Hairston's been sitting in jail for hundreds and hundreds of days. Why do you need more time? And if the answer was because I'm busy, I'd say, but we all are. But that wasn't his answer. And I pushed him to be sufficiently detailed while protective of privileged information to let me know that there were defense theories, not just that he had, but that you had, and that you had articulated to him. So I'm not disagreeing with you if you say you've met 5 times or 6 or whatever the number is. Clients who are in custody rarely think they've seen enough of their lawyer. It's difficult for the two of you to connect. It's not simple to do that at the jail. It's particularly difficult for Mr. Banks or any lawyer to share, for example, digital evidence. Here's some body cam. I have to sign a special order, which your lawyer asked for, and I signed, so he's taking care of all that. But defendants who are in custody rarely feel like they've had enough time. But that's not the test. Because then we would have a defendant able to say, I still haven't had enough, and we're going and going until the defendant says it's just right. It's a judicial determination of whether there's been adequate time and adequate interaction. And I'm telling you that based on things Mr. Banks has been able to share with me about his thoughts about when to move forward and how to move forward, and resources that he was trying to pull together on your behalf, that Mr. Banks and his team are more than adequately prepared, and that he has had enough time working with you to get a feel for your theory of the case, but more importantly, his, because he, if you end up having a lawyer representing you, he's the advocate, and he's the one empowered to make those decisions of, you know what, we're not going to use, I'm making this up 100%. We're not going to use self-defense. That's not credible because the victim was shot 3 times in the back, and that's not self-defense. So I know you're saying it should be self-defense because the victim was 2 feet taller and had beaten me up 4 times earlier in the month, but I can't use that defense. So we're going to use something else, accident or alibi. And ultimately, that's the lawyer's decision and not the client's. But of course, there need to be communications about it. And I know you've had communications because Mr. Banks has said, because of the conversations I've had with Mr. Hairston, I need to do X and Y and Z. And that takes time and resources. And so, Judge, I'm asking for a continuance. And I've said, yes, you can do that. But I made plain to Mr. Banks that the last time he asked for one, not because of his schedule, but because of work he was doing on your case, that was the last time. And so let's set this case far enough out that when we reach it, you, Mr. Banks, will have had enough time to do the things you need to do, which is how we arrived to Monday. So I hear you that you would like to have had more time with your legal team and that you feel like there has been inadequate communication. But that leads me to say, you can choose to represent yourself if you feel like your team isn't going to do an adequate job, or you can let this team that I'm finding has demonstrated that they are prepared and that they understand the dimensions of your case, the strengths and the weaknesses and the problems that a defense has to overcome in this case.
Your Honor, may I?
You sure can.
That's the problem right there. The things that you and Attorney Banks may have discussed have never been discussed with me. And therefore, I believe the things that he said to you are not true. I don't really trust him in the fact of that's the things that you just stated are things that have never been communicated to me. And it's not my purpose in delaying trial. I want things to move on, the proceedings to continue. But how can I believe someone has my best interests at heart? How can someone defend me in this relation with not even discussing anything with me? He's, again, 5 times, the 5th time being Sunday. The last time I saw Attorney Banks was in November. And so, yes, we got the continuance that was granted on December 2nd, but I hadn't seen him until Sunday.
And if there wasn't a whole lot to report back because there hadn't been a whole lot that changed with your case, what would a meeting in December have been all about? We're only talking about a couple of months anyway. You're making it sound like it's been a year, but it's the holidays, it's a couple of months. And if there isn't something new to report, what's the purpose of a meeting?
Your Honor, there's been nothing that has ever been reported. And that's the issue that Attorney Banks and I have. There's why there's no trust there. There's more than just communication issues. Everything that he said to you isn't true. It's not factual at all. The things that him and I have discussed have been nothing. We haven't discussed anything as it relates to my case. So although things may have not changed from November to now or from any time before that, we still haven't discussed anything prior.
Okay, well, I'm hearing 2 different versions, and I'm going to credit the one I choose to credit. But again, you are the decision maker in terms of representation. And I need you to let me know how you want to move forward on Monday. We're getting close here today, so we'll get you dressed out. And if you want to represent yourself on Monday, you can do that. But there's a whole conversation we need to have about the wisdom and really the lack of wisdom of self-representation. But we aren't going to switch lawyers again. You have the able, capable, and prepared legal team seated on either side of you that's ready to go on Monday. And you can move forward with them or you can move forward solo. I just need you to let me know which of those, there's not a third option. Other than, like I said, you could bring someone else in, but option 3 is not, hey, you know what, let's get together again in 3 months. So you feel a little better about the situation.
Your Honor, I do not want to represent myself.
Okay.
I don't understand how or why I would be forced to have Attorney Banks when our relationship is non-reconcilable.
So if Mr. Banks asks you questions about witness X, are you going to answer those questions or are you going to refuse to interact with him?
Your Honor, our relationship has been severed. There's no way for us to move forward.
Well, you are actually telling me then that you're going to represent yourself, because if you're not going to work with Mr. Banks, then you're going to work with yourself. You don't get to play the game, because this is what it's becoming of, you know what, here's another lawyer. I'm not going to work with this one. I need to get that lawyer that's just right, and then I'll move forward. Nope, Mr. Hairston, you have 2 choices. You're going to work with the lawyers who I find to be prepared and have your best interests in mind. And you don't get to say, I'm not going to talk with him. You can say, I'm not going to talk with him. I refuse to interact with my lawyer. That makes it a whole lot harder for your lawyer, or you can represent yourself. But if you want your advocate to benefit from your insights, then you may want to interact with him. But I don't control that dynamic. You do. I just know that you've got 2 lawyers flanking you right now who have your best interests in mind and are ready to move forward on Monday. You can make it easier for them by meaningfully interacting with them, or you can cross your arms and say, our relationship has been severed. You actually don't get to sever that relationship. I'm not, unless you tell me you want to represent yourself. And then we have that conversation where I can conclude that you actually are knowingly and intelligently making the decision to represent yourself. Yeah. So I'm happy to let you talk with your lawyers for a little while longer while I turn to some other matters, but you are trying to create a third option that you don't have.
May I, Your Honor? I'm not trying to be difficult. I'm not trying to represent myself. I don't have the capacity to represent myself. I never chose to get rid of any of my attorneys. This hasn't been an issue of me trying to delay this case in any way. I chose the attorney that my family retained.
We lost the audio from the court
Sound
there.
went out.
Oh, it's back. Not back. Bump it forward a little. We're in the Wayback Machine. There we go.
We're not going to delay for you to try to find another lawyer. 1, I don't know how you're going to afford that other lawyer, but 2, you've got lawyers who are ready to go.
Your Honor, if I may, I just want the opportunity for a fair trial. Because of the relationship that Attorney Banks and I have, where there's no trust, I know that I can't represent myself. I'm just asking for, because I am indigent, I'm just asking for a court-appointed attorney that can just
keep going,
where trust can be built and we can establish some sort of conversation and communication that will be to my benefit. That has just been something that hasn't occurred with Attorney Banks and myself.
Mr. Banks.
Judge, look, I don't have much to add. I do dispute that I've lied to this court, obviously. I take issue with that. I don't make representations to the court cavalier. It's a serious matter. He's facing serious charges. Having said that, I remain willing and open to work with Mr. Hairston in this serious matter. In fairness to Mr. Harrison, I will say he's been given a raw deal insofar as the representation. I stepped in to help two other colleagues out, and so I will continue to do that as best as I can under the circumstances. But I feel his pain in some respect. I really do. I have had the case less than a year. I know the court has been very clear with its direction to me concerning moving this case forward because it is, as I understand it, one of the older cases on this court's docket. And Mr. Douglas has been sitting in jail for an extremely long time. And of course, the victim's family has been waiting their day for this to be resolved as well. Without getting into attorney-client privilege about what we have communicated and what we've not communicated, I will just simply say that, one, again, I feel his pain concerning the time he's been able to spend with me. But that's all I can say.
Okay, no, I appreciate that. And I believe I started the conversation by noting that this is not one of the cases where there's a defendant who keeps firing lawyers and it's plain from the conduct that it's just an effort to delay things. That's not your situation at all. You had to move on from the lawyer your family chose, not because you two didn't get along. I get that. Mr. Banks has been in this case for enough time. It was May 25th of last year that he came into the case to be prepared. I believe he is prepared, and I'm confident that he can zealously defend you. I also, because I've had a number of hearings about your case, know that your defense is going to be complicated. The evidence is not great for you. I don't know that the defense is going to be someone else did it. It's not a case I necessarily want to pick up and say, I've got a phenomenal defense for it. But that's not a sign that your lawyers aren't trying or that your lawyers aren't skilled. Sometimes the evidence is problematic for the defense, and sometimes it's not. But I want to turn to Ms. Willingham and see if the state has anything to add. And then I'm going to have you and your lawyers talk a little bit back there, and you can let me know with finality whether you want to represent yourself or if you want to move forward with the legal team that has been working on your behalf, even though you don't feel it and you claim that the relationship is irretrievably broken. We're coming up on 9 months now. And so I do believe they're prepared to do what they can on your behalf. Ms. Willingham, anything you want to add from the state side?
Judge, not much. The only thing I would speak to is, I know the defendant mentioned something about getting a court-appointed attorney. I would just argue that although I know Mr. Banks is technically a private attorney, I think that, quite frankly, Ms. Miller also even acknowledged that I am not in private work, so I don't know what they charge, but she acknowledged herself that realistically, the amount of work that this case would have taken for any of them, those funds would have been exhausted well before I've actually left the office for 7 months and came back. And she said those funds would have been exhausted very early on. I believe almost right after our bond hearing which was, I think maybe a week after the plea and arraignment. So with that, again, I recognize that, Mr. Banks is a private attorney. The defendant has essentially had the work of a unpaid, or I'm not going to say unpaid, but a public defender, just by way of a private attorney who, quite frankly, I've had several conversations with Mr. Banks. So I think that he's more than ready to proceed forward on this case next week. So that would be all from the state.
Is there any evidence that you have come across very, very recently such that there would be a basis to say, hey, I would be ready, but the state just gave me the cell phone extraction from Mr. Hairston's cell phone?
Judge, no. There were a couple things that I sent over to Mr. Banks again, but it was more so because I just wanted to make sure that everything was streamlined. In fact, we even spoke at great length about making sure that we were looking at all of the right video footage and that everything was. He's had everything for quite some time and has inquired about a lot of that evidence, but there's nothing new that has been turned over that I think would make any difference at this point.
So maybe put differently, the state's file was complete even during the Ms. Miller or maybe the Mr. Johnson era. I know you went above and beyond to ensure that Mr. Banks basically got everything again because there was a lot of difficulty retrieving Mr. Johnson's files. I recall Mr. Richardson and Mr. Walker saying, we're doing our best, but Mr. Johnson really was focused, as he should be, on his health. But if we go back to May or June of last year, that's when you were pushing across to Mr. Banks and his team. Hey, I'm just giving you this again. Maybe you get it from Mr. Johnson, maybe you don't.
Yes, Judge.
Okay, understood. Anything else, Mr. Banks, you want to add? I'm not, I just wasn't sure. I couldn't tell if you had something you wanted to say in response to what Ms. Willingham said.
You know, anytime a client expresses, the deterioration of a relationship, it does give me pause, if I'm to be honest with the court. And I understand the court has to make a decision as to what his options are. While I've tried to keep the lines of communications open with Mr. Harrison, I am concerned about continuing my efforts to speak with him because it will require his active participation.
Right. Okay. I appreciate that. Mr. Hairston, here's where we are, and I'm going to sound sort of like a broken record, or at least that I'm repeating myself from the beginning. I find that, Mr. Banks, I don't mean to be incorporating your associate. When you go forward on Monday, assuming we go forward on Monday, we'll both, you Mr. McCrimmons, is that correct? That's right. Will you both be here? Okay. So this legal team, not just one lawyer, but two working on your behalf, I find that they are prepared, that they have had more than enough time to process the state's evidence, and that they can more than adequately represent you and your interests at trial on Monday. You, Mr. Hairston, are going to decide how much easier you make it for them by meaningfully interacting with them. I can't force you to be a partner in the process, but we are going to go forward on Monday. And the one variable would be if you decide I want to shed them, that they actually are going to make it worse than if I do it myself. And I haven't heard you say that. I don't think that's what you're going to do. So I guess I'm encouraging you to reevaluate your position about interacting with these lawyers. You will make their job harder if you don't interact with them when they have questions or when you have thoughts and ideas that you want to share with them. But I don't find that you are facing a situation where you have lawyers who are unprepared, don't know what the case is about, or who haven't made good faith efforts to maintain a relationship with the client. And I'm not going to let you sabotage it so that we don't go forward on Monday. There have been months and months for us to have dealt with this, and it's an interesting coincidence that it comes up now. But I just want you to understand that you'll be back on Monday morning and we'll be going forward, and you're going to be making the adult decision of whether you collaborate with your lawyers or if you sit there sullen and choose not to assist them as they try to navigate the trial. Okay?
I don't have a choice.
I've told you your two choices, and you've told me you're not interested in representing yourself.
I didn't say I wasn't interested. I said I'm not capable.
Okay. Do you want to have the conversation about representing yourself, or do you want to save that till Monday because you're going to think about it more?
I'm not capable of representing myself.
All right, then we'll stay away from that one. And then that says to me, absent someone showing up on your behalf on Monday saying, nope, I'm here for Mr. Hairston, then you understand what we're doing on Monday. Okay? Thank you, Mr. Banks, Mr. McCrimmon.
We go to the back. just-
Yes. Oh, yeah, we've got that. That'd be great.
And Judge, unless I'm needed back, may I be excused?
Yes, ma'am. We have an afternoon calendar, but I don't think you'll know if you have something on it.
But I'll log on.
Okay, sounds good. Appreciate you being here.
Okie dokie, friends. That's what's going on in Georgia at the moment. Once again, everybody, good morning. TCF Live. It's Super Friday. Let's go here. We haven't been here since the last time we went here, and that's a fact. Let's, Miami-Dade. Judge Glazer. Let's see if she shouts Spanish really loudly.
Drogas ilegais.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Proibido a posse ou portar armas, armas de fogo ou qualquer munição.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court.
É obrigatório a senhora entregar imediatamente para o departamento de polícia qualquer arma de fogo ou permissão de armas escondidas que a senhora possa portar e trazer recibo aqui para nós.
And also, you may return to the victim's residence one time only within 48 hours of your release from jail.
E a senhora poderá retornar ao local da ocorrência somente uma vez com a polícia até 48 horas após a sua liberação, a sua soltura.
You must be accompanied by a police officer
Será obrigado o comparecimento lá com a polícia,
so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools.
para que a senhora consiga recolher os seus pertences pessoais, como roupas, itens de higiene, medicações, ferramentas e papéis de trabalho.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Se a senhora for até a residência da vítima sem a polícia ou se a senhora permanecer lá, a senhora será detida.
You understand the stay away order?
A senhora entendeu a ordem de afastamento?
Sim. Okay,
Yes.
fine. I'll find probable cause. I'll give a How long have you lived in Miami?
Ok, foi encontrado justas causas. Há quanto tempo você reside em Miami?
Mais ou menos 4 anos.
Approximately 4 years.
Okay, pretrial services, alternate bond. Count 1, aggravated assault with a deadly weapon is $2,500. Count 2, battery is $1,000. Have a nice day. Make sure to keep all future court dates. And hire an
Então, senhora, eu vou estipular para a senhora o programa e a fiança para a imputação número 1, que é a agressão agravada com arma letal, será $2.500, e na acusação número 2, que é a agressão, $1.000. Boa sorte, tenha um bom dia.
Obrigada.
Thank you. Wait a second. How long are you living here? Because you told the pretrial people it's 5 months.
Há quanto tempo você mora
in this
lá?
apartment is 5 months, but in Miami is about 4 years. Before we live in Coral Gables.
What did you say?
Before she lived in Coral Gables.
Oh, okay. Pretrial's fine. Have a good day.
Thank you.
Foi liberado o serviço pré-julgamento. Tenha um bom dia, senhora.
Correction, Rosa V. Villarreal, stage 3.
Anything else from the Portuguese interpreter, Your Honor?
Oh, no, you're free to go. Thank you so much.
Of course. Have a great day, Your Honor.
You too.
Nice seeing you.
So number 11, Tita Villarreal, is that the private attorney cases. Then I need Ira, Hal Walker, Nadar Abed, and then Eji4 Onyeki. Of course, this has like 15 pages to read it.
Sorry.
Fortunately, I've read this before. There you go. Can you correct here? Can you tell them? Is the person there? She's coming up. She's coming up, Judge. Hello, ma'am. Do you speak English?
Yes,
Good morning. You were arrested for 1 count of conspiracy to commit arson, a first-degree felony. This is a case from March 25th of 2025. Your attorney is present. Good morning. Tell me your name for the record, please.
Yes, good morning, Nicholas Santo.
So Judge, just briefly, it was her boyfriend who set
Wait
the
a minute.
fire.
Stop.
Nicholas Gonzo.
No, but have clear-
CON is in zebra.
One second. Okay, yes, Ms. F.
Okay, so just briefly, it was her boyfriend who set the fire to his ex's house. It was a terrible fire that resulted in very significant injuries to the victims that were inside the home.
That one
at the
victim was a
time.
child, two, a teenager.
So in terms of her involvement, it looks like at one point she exchanged vehicles. Additionally, there are some text messages, screenshots that she took from the DHSMV, citation numbers. So it looks like she did some, I guess, online research in anticipation of her boyfriend setting this house on fire, and she knew his intent. He sent her a text. I appreciate your support. I'm on a mission to get revenge. It looks like she sent, I guess, her research to the other parties who were involved in coordinating this terrible fire. So she's charged as in the conspiracy to set the fire.
Okay.
Ultimately, she can speak to her boyfriend. Her boyfriend can say that he has an issue with his ex-girlfriend. Circumstances can be provided with respect to that, but for proof of conspiracy to commit arson, we need to show intent from this individual, Ms. Villarreal, that she had any intent that an arson be committed. The facts of that four corners of the are completely devoid of that. There is nothing whatsoever. She dropped off a vehicle to exchange to get her boyfriend's vehicle back. And two other individuals went to this house. The boyfriend wasn't even the one that set the fire for the arrest affidavit. So ultimately, Judge, there is no DC.
No, I heard what nephew they said or cousin.
Yeah, good.
Let me read this. Give me a second. Where does her stuff is on, where it says 11 of 18. Have a seat. Be a while. I gotta read all this. But okay.
Well, we're waiting on Judge to do her reading. Good morning once again, everybody. TCF Live on a Friday. Nice to have you all here. Members, if you missed the pre-show this morning, which you might have because it went out, the notice for it went out late, go back and watch after the show. I brought proof that aliens exist. Serious proof. I read it off of 4 sheets of paper. Those who were there will attest to it. And I see in this morning's news that Trump has told the Department of War or Defense or whatever we're calling it these days that they have to declassify the information that they have on aliens. So there's that. Seems like she's going to be a minute here. Let's do this. Let's stay in Florida, but let's go over to Wade Mercer.
Ms. Pearson, good morning, ma'am. Ms. Pearson, your mother is in the courtroom on your behalf. You're accused of 1 count of driving under the influence and 1 count of refusal to submit to a blood or breath alcohol exam. Ms. Pearson, there is probable cause for the charge. Ma'am, it appears you have no criminal history at all. So I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, and we'll see where we go from here.
Your Honor, we just asked for conditional release and come back for March 30th court date. And
Mr. Mitchell?
No objection to a conditional release.
So, Ms. Pearson, I'm gonna let you pick between a bond and a conditional release. Anytime I offer a conditional release, I give the person a bond choice because some people prefer that. If you choose the bond and your bond amount is $2,500 cash or surety, I am going to offer you a conditional release based upon your driving record and your criminal history or lack thereof. You have a condition not to possess or consume alcohol. You do not have a license. Your license is suspended. Now, the only way she can get a license while this case is pending, Mr. Goodson, is she would have to challenge it administratively.
She doesn't do that. She can apply or try to enroll in DUI school. After 90 days of dead time, she can apply for a business permit if she shows proof of enrollment.
Okay. So I want you to understand, you do not have a driver's license right now. You may be able to get a work permit or what they call a business permit, possibly, but there's going to be a dead time. You've got 10 days, like I think the officer probably explained, or it's in your citation, to request an administrative hearing if you want to challenge the refusal part of it. But if you get caught driving without a license, that's going to violate your conditional release and you're going to be in jail with no bond. If you get caught drinking or consuming alcohol or possessing alcohol, that's going to violate your conditional release and you're going to be in jail with no bond. So no driving without a license and no alcohol at all. Ms. Pearson, do you want to choose the bond or the conditional release, or do you have questions?
Your Honor, I guess with their parents there, would they be willing to come up to the jail and post a cash bond of, $250 if the court's agreeable?
No, well, there are 2 charges, so I misspoke. It's actually $2,500 each. So the question is, if she's on conditional release, ma'am, I know that you hadn't had a chance to speak to Mr. McDaniel. Here's the difference. A bond, if I said a bond, Mr. Mitchell's probably not going to object because it's a first offense DUI, Mr. Mitchell.
Correct.
So her bond will be $250 on each count. It's $500 cash. The only conditions of a bond in her case are don't miss court dates, don't be charged with any crimes, don't possess or consume alcohol, don't drive without a license. Okay? Her other option is a conditional release. A conditional release, there's a trade-off. A conditional release is cheaper usually because it's only $30 a month, but it has more rules to follow. On a conditional release, she has to call in once a week to a conditional release officer. On a conditional release, she's got to pay the cost of supervision, which is $30 a month. On a conditional release, she can be drug tested. So conditional release, it's almost like probation while the case is pending. So it's more structured and there are more rules to follow. It has all the conditions of a bond plus other conditions. So she gets to pick whether she wants to get out and be cheaper by taking the conditional release or put up more money to get out of jail, but have less rules to follow. If you choose a cash bond and if there's a fine imposed, Florida law says the cash bond has to be put towards the court costs and fines. The person that puts up the bond does not get it back. On the other hand, if you choose a cash bond and the case is dismissed, the money that put up the cash bond, the person that put up the cash bond would get it back. So her question, I believe, is, do you want her to post the cash, you want to post the cash bond for her, or do you want to accept the conditional release and have more rules to follow? We've got other cases, ma'am. You got to make up your mind.
Madison, I think you should just do whatever you feel like you should do.
She said you do whatever you like. So what do you want to do, Ms. Pearson?
Just do the conditional release.
I'm going to grant you the conditional release. So here's what's going to happen, ma'am. They're going to let her get dressed. They're going to let her use the phone if she needs to. Then they're going to bring her to the courthouse because the conditional release office is in the courthouse. The probation office, the supervisors of conditional releases. They're downstairs in the county judge's office on the east side. That usually takes 30 to 45 minutes. So in 30 to 45 minutes, she'll be here. She'll meet with a conditional release officer. They'll explain the release to her. They'll answer any questions that she has. You can hear that conversation. They'll give her a copy of the rules in writing, and then she'll be free to go. They're also going to give her notice for her next court date, which will be March the 2nd.
Yeah, docket came out yesterday, so we're now in the.
Is that the cutoff? Is it cut off early, or is that the regular cutoff? Okay, so her court date will be March the 30th. March the 30th at 9 a.m. will be your notice, and the conditional release officer will give you that notice when you get here. So she can be picked up in about 30 to 45 minutes downstairs. And do you have any questions? And Ms. Pearson, do you have any questions?
No, sir.
All right, thank you. All right, wish you the best, Ms. Pearson. We'll see you March 30th. Next case is Robert Clements. Mr. Clements, good morning. Mr. Clements, you're here for one charge of sale of a controlled substance, methamphetamine. Mr. Clements, I think I'm the judge that issued the warrant, and at the time I issued the warrant, I put a $25,000 bond on that warrant. 99% of the time, I don't put a bond on warrants. I put no bond until first appearance. But when I saw the warrant and I saw the bond, that tells me what that tells me is that there was a long time between the alleged act and the arrest, and I wasn't provided a very good reason for that. That's the only time I set a bond, primarily. That's the only time I would set a bond. But at the time I said that bond, I'm not aware of the person's criminal history. So now when you come to first appearance, you haven't posted the bond. Now I'm aware of your criminal history, which shows that you've been to prison 4 times for methamphetamine-related charges. Is that correct, Mr. Clements?
No, 3.
You've only been to prison 3 times?
3 times.
Okay. So, Mr. Clements, I'm going to listen to the attorneys, and I'm possibly going to adjust your bond based upon your criminal history, but I want to see if they have any information first. Mr. McDaniel, anything?
We just asked for a reasonable bond.
Okay. Mr. Mitchell?
We just asked he be subject to random UAs.
I'm pretty sure at least one of those prior criminal prison sentences was related to a delivery of a controlled substance, not a possession. I'm going to double check that because I don't want to increase your bond unless I think it's appropriate. So let me look at the DOC website. Mr. Clements, give me just a second to get that pulled back up. Their website shows that you've been to prison 3 times. You're correct. Most recently got out in 2023. And 2 of those charges were related to sale of meth in 2010 and then again in 2013. Your bond today is $50,000 cash or surety based upon your criminal history and the charge you're accused of. You have a condition of random urinalysis. You have the right to post the bond, sir. You'll use the phone in just a few minutes, sir, to try to post that bond. Mr. Clements, the jail's going to give you a notice for your next court date, which would be March the 3rd at 8:30. And you'll use the phone in just a few minutes. Do you have any questions, Mr. Clements?
No, sir.
All right, sir. I wish you the best. Randall Pittman.
Today's that cut off for the felony court date, right? Oh, okay.
I don't know why they're not the same. It'd make our lives easier if they were the same, huh? Mr. Pittman, good morning. You're here for accused of one count of burglary of a dwelling. Mr. Pittman still have a case pending, the one he was representing himself on that he took Mr. McDaniel late?
No, I dismissed that case after he served the max sentence already or was in custody for that.
So that case is no longer
Yeah,
pending?
those cases are no longer pending.
So, Mr. Pittman, as far as I can tell, then you're entitled to a bond in this case. There is probable cause for the charge. I'm aware that you've been arrested, I think 3 times within the last 4 to 6 months, probably. So I'm going to set you a bond, but I'm going to listen to the attorneys first. Mr. McDaniel, anything on behalf of Mr. Pittman?
It's my house. Your Honor, just that it's, the house he is an heir to the house.
My
So
TV.
You want, and, obviously that's back to the case the jury decide, but, he basically wants to say that it's his TV and.
Yes, sir. And also my brother, drank about 20 beers, before he made that call. My brother needs, treatment, just like my mother, and he's not getting the appropriate treatment that he needs.
Okay. All right. Anything from the state, Mr. Mitchell?
We just request he have no contact with that property or the victim.
Mr. Pittman, your bond's going to be set at $25,000 cash or surety. This is a second-degree felony, and it's your third arrest in the last few months. You have a condition, no contact with that property at all. If the case is dismissed, that may, if the probate goes through, that may change things. But according to the complaint, you had a trespass warning at that property in effect at the time that you allegedly went over there. Let me finish. No contact with that property at all. Mr. Pittman, don't talk about your charges, but if you have a question, if it's a question I can answer, I'll try to answer it. But I don't want you to say something that's going to hurt yourself. Do you have any questions?
Yes, Your Honor. I have two brothers, who do not want my mother at the house. So what they're doing is they're taking, checks out of my mailbox that have my name on it and putting them in a bank that I don't have access to in order to keep my mother in jail. That's their the whole purpose is to keep my mother in jail. They're taking checks out of my mailbox. I had a trespassing order on both of them. They violated the trespassing order and took checks out of the mail. And that's why me and my mother can't bail out, because they are, well, the sheriff's department is helping me, is what's going on. The sheriff's department is, my brother's working for the police right now. They do not want my mother on the streets.
Yeah, Mr. Pittman, that's not a question. That's not a question at all. I was very clear. That's not a question. I wish you the best. Have a good day, sir.
Well, sir, can I
His
ask one
first
question
appearance is
then?
completed. Corporal, he just want to talk about the case. I don't have time to listen to it anymore. He's got a bond set. Wish him the best. Choice Ford is next.
I don't know if we gave him the court date, but it is March 3rd.
Corporal, please give him a notice for his arraignment date in felony court, March 3rd at 8:30. Choice Ford. Ms. Ford, good morning. Ms. Ford, you have a fugitive warrant out of Houston County, Alabama. Ms. Ford, I'll wait till you get through signing that. I don't interrupt you. I'm assuming what Mr. McDaniel just presented you while I was talking was a waiver of extradition. Is that right, ma'am?
Yes, sir.
Okay, Mr. Ford, do you have any questions about that waiver of extradition?
No, sir.
All right, so ma'am, what that means is they have 30 days to pick you up. That time starts today. If you're still here in 15 days, I'll see you and we'll see get an update, but there's a good chance you won't be here anymore. They already picked you up. You have any questions?
No, I don't.
Have a good day, ma'am. Gary here. Mr. Hill, good morning. Mr. Hill, you have a hold out of Calhoun County. I pulled up the warrant this morning, and it appears to me that it has the teletype from them doesn't mention a cash bond. But when I looked at the warrant itself, it appears to have a cash bond on it of $432. Corporal, does that match what y'all show?
We only got the teletype, but I believe that's correct.
Mr. McDaniel?
That's just what I saw, was a $432 cash bond.
Yeah. So I'm going to ask the jail to verify that. Again, their sheriff's department doesn't mention a bond at all. They just say that they have a warrant for you. But when I look at the warrant itself, it looks to me like it's got a $432 cash bond. I'm going to ask the jail to verify that. They'll notify you after first appearance. If you post that, you'll be released, Mr. Hill, if that's accurate. If you're not able to post it, you'll go to Calhoun County and you'll go before a judge there. Any questions, sir?
No, sir.
Have a good day, sir. We have Michael Eubanks. Mr. Eubanks, good morning. Mr. Eubanks, you're here for a violation of conditional release and a failure to appear warrant in the same case. Both of them have no bond on it, Mr. Eubanks. What that means, sir, is you're going to be held with no bond until you can get to circuit court and try to get this case resolved. Well, do we know when Judge Garcia's next pretrial date is so we can tell him when we think he's going to be in court?
Isn't it? It's for the 17th.
So you don't have her
I might be able to find it. Give me just a
Can
second.
you make a note to request that, please?
It looks like it's going to be March 10th.
We believe her next court date for pretrials is March 10th, Mr. Eubanks. Do you know who? Well, I'm going to ask Mr. McDaniel if he knows to notify your attorney that you're in jail. Sometimes they can tell from their computer system who your attorney is. And Mr. McDaniel's really good about sending an email to them so they'll know you're in jail with no bond. And usually they'll prompt them to go ahead and come see you. You have no bond for at least for right now. Any questions, Mr. Eubanks?
No, sir.
All right, sir. Wish you the best.
It's Wade Owen, so he'll be happy to see him.
Thank you. Eric Burgess.
Yes, sir.
Mr. Burgess, good morning. Mr. Burgess, you're here because you've been accused of 4 charges: driving under the influence, fleeing and attempting to elude law enforcement. That's the 3rd-degree felony version. Obstruction without violence and reckless driving. I read the complaint and there's probable cause for all of those charges. Mr. Burgess, I'm going to appoint the public defender's officer to represent you, Mr. Burgess. I'm going to ask that you listen to Mr. McDaniel and we'll see where we go. Mr. McDaniel, anything?
No, we just asked for a reasonable bond.
Mr. Mitchell?
Nothing at this time, Your Honor.
Okay. Mr. Burgess, I have looked at your history. Your criminal history is pretty lengthy. So I'm going to set your bond at $3,500 on the misdemeanors. There are 3 of those. $7,500 on the felony fleeing and eluding. That makes your total bond be $18,000 cash or surety. Your bond has a condition that you not possess or consume alcohol nor have any. This is an alcohol-related DUI? Can't remember. Yes, it was.
So, yeah.
Not possess or consume alcohol. Actually, I don't know that it was alcohol-related DUI.
I'll double check.
No, may I say something?
Don't answer that question at all, but I believe the allegations were that he was under the influence of something other than alcohol. So you'll have a condition of random urinalysis, Mr. Burgess. But you have the right to post the bond, sir, and you'll get to use the phone in a few minutes to try to post the bond. Mr. Burgess, also the jail's going to give you a notice for your court date, which we think will be March the 3rd at 8:30. And you'll get to use the phone in just a few minutes. Mr. Burgess, do you have any questions?
No, sir. Thank you.
Yes, sir. Wish you the best. Mr. McDaniel, anything else for first appearance purposes, sir?
No, Your Honor.
All right, he's done with first appearances. Let's go back up to Michigan. Judge Jason Elmore, see what's going on there.
And anything else from the jail this morning, sir?
Taking up the case here of people in the state of Michigan versus William Forrest Manicky. Now, this is file number 25-14058FH. Appearances, please.
Nick Hearns on behalf of the people. And I'm Jeff Harrison. I'm here on behalf of Mr. Manicky. That is him on the video screen appearing from the jail.
Mr. Manicky, are you able to see and hear the court?
Yes, sir.
All right. Also before the court is Mr. Stephen Saladay, an agent from the Michigan Department of Corrections, serving as the probation officer here today. We are here today for an arraignment on a requested warrant for a probation violation. Like there had been a previous no cause. Hold on. There was a request and summons for a probation violation that was filed on January 21st. The court ordered the defendant to appear on February 5th. Failure to appear, a question warrant was filed. However, before we he did appear, I'm sorry, and then I released him on a PR and then failed to appear on February 9th. Thank you very much. All right, so Mr. Manicky, we're here today for this probation violation hearing. I still think I need to advise you of, there's an amended charge, Mr. Saladay? No? Made it a requesting warrant with the same charges. Yes. All right, thank you. So, Mr. Manicky, we're still facing 4 counts for violating your alleged terms of confinement. allegedly violating the terms and conditions of your probation. Again, count one is that you were not in your approved residence between curfew hours of 10 p.m. and 6 a.m. on January 7th of 2026. Also that for count two, that you consumed alcohol on that same date. For count three, you failed to appear for your show's cause hearing on, so we did have the count, on February 9th of 2025. So that's a new added count. And then also you had count four, that you actually committed disorderly conduct on or about January 7th of 2026. Mr. Harrison, what are we doing today?
I would like the opportunity for an informal, if that's not available. I believe I had some preliminary discussions with Mr. Saladay, but in the interim, I was unable to locate Mr. Manicki and they never proceeded beyond that.
Okay.
I can do that.
Well, let's see, what, how many final pretrial conferences are yours this morning?
Three.
Three? Right.
Then there's the motion in the AG's case.
All right.
And I believe two pleas, but.
Okay. All right, well, first of all, Mr. Manicki, again, I've gone over those four counts. I need to tell you once again that, as I told you before, you have the right to challenge not just the first three, but also now all four alleged violations of violating your probation. You have the right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to be represented by counsel at the hearing, as well as any subsequent proceeding. Also, the right to question and cross-examine any witnesses against you, and the right to present witness evidence for testimony if you choose, and also the right to remain silent and not have that silence used against you. If you're found to be in violation of your terms and conditions of probation, you would be resentenced on your original offense. Was this resolved with a UDAA or the unlawful use version?
Unlawful use, Your Honor.
All right, so that's the misdemeanor,
Yes.
and that's punishable by. Oh, there we go. It didn't get tagged. It's actually a high court misdemeanor punishable by up to 2 years, $1,500 plus suspension of the defendant's driver's license. And based upon the fact that there's at least one non-technical, the court is not limited to a sliding scale. All right, thank you. The court will adjourn the day, have it set for an informal hearing. Now, to do that, since today it starts 14 days, again, because I had to re-advise them of count three.
I will happily make a preemptive waiver of the 14 days due primarily to my unavailability in the first part of next week.
No problem, I understand.
I don't want to lop over a date just because I'm in a trial.
I'm in a trial too. So.
Yeah.
All right. The court will continue the not guilty plea. The court will continue to have it set for an informal hearing. Anything else to hear from Mr. Carnes?
Your Honor, I would just ask that the court remand the defendant pending the hearing given to.
Oh, that goes without saying. All right, Mr. Harris, unless you want to, you get the right to make an argument. Maybe there's something I don't know out there. Maybe he was working special forces someplace I don't know.
No, at this juncture, I believe that a remand actually makes sense.
All right, thank you. The court's going to deny the defendant's bond and remand him into the custody of the Washington County Jail pending that informal hearing, which will be within maybe the next week, if not within the next 2 weeks. Thank you.
Thank you, Your Honor.
We are adjourned.
Okay, folks, let's head back down to Florida, but this time we'll say good morning to Brantley Clark.
I would call Ms. Harris.
Always for the testimony you're about to give the truth, that the truth is about God.
Yes. All right, state your name for the record for me.
Jamira Harris.
Jamira, sorry about that. And so have you lived in Bay County very long?
Port St. Joe in Bay County.
Okay, and how long have you lived in those two counties?
My whole life, back and forth.
All right, and were you working before your arrest?
Yes, ma'am.
And where were you working?
The Goodwill in Port St. Joe,
And were you working part-time, full-time?
full time.
Do you know if they still have a job for you?
Yes,
Okay, so they would take you back so you have a place to go and work?
yes, ma'am.
Do you also have a place to live?
Yes, ma'am.
And where would you live?
249 Avenue C, Port St. Joe, Florida,
Is that by yourself or with someone else?
with my grandmother.
Okay. And what family, besides your grandmother that we just heard about, what other family members do you have here?
I have my father, he's present in the courtroom back there.
Okay.
That'll be pretty much all.
Okay. Do you have brothers and sisters, aunts, cousins?
Yes,
All
but
right.
just no contact.
Okay. But they do live in this area. So basically most of your family is in Bay and Gulf County?
Yes, ma'am.
All right. And are you able to post the bonds as they're currently set, 3,000 on count one and 7,500 on count two?
Yes, ma'am, but I just currently have children that my family are watching, so I would just like to get it a little down, a little lower.
Okay, so you don't have the funds right now to post those bonds, is that correct?
No, ma'am.
Okay, and what funds do you have? What bond do you think you could post if the judge were able to lower it?
I'm just asking that he lowers the 7,500 one.
Okay, down to what?
About 4,000.
Okay, so are you needing 4,000 total or 4,000 on count two and 3,000 on count one?
I don't understand that.
Okay, the total amount of money you think that you can post is what?
Oh,
Total.
okay, yes, ma'am, about 4,000.
Okay,
Yes, ma'am.
all right, no further questions, Your Honor.
Any questions, Mr. White?
No, Your Honor.
Any other witnesses?
No, Your Honor.
They have any witnesses?
No, Your Honor.
States, have any argument?
The state would object to any modification of the bond. The defendant has a previous conviction for aggravated assault on a Leo as well as a resisting with violence charge. And given the nature of what she's charged with in this case, the bonds as they are currently set are more than reasonable.
Your Honor, she's not a flight risk. There's been no testimony about any kind of failure to appear. She's got family, she's got a job. And she's got children out there. She's got two of them. I know we didn't take testimony of that, but one has just recently she just recently had one of her children. So I think a $4,000 bond is perfectly adequate to ensure that she returns to court.
She's charged with aggravated battery, which is a second-degree felony, and burglary while armed, which is a first-degree felony punishable by life. So I believe a total of $10,500 bond is a reasonable bond on those. So I'm not gonna raise the bond, which I'm thought about doing, but I will leave the bond as it is. All right, we need another court date.
Can we return in April? I'll need to get depositions set.
What did I do with the cheat sheet? April was that 23rd at 9 o'clock?
I have Jonathan Bearden. Your Honor, this is Jonathan Bearden, case number 254023, and we're here for a bond reduction hearing.
They call you first witness?
Defense would call Linda Moore.
Yes, I do.
All right, state your name for me.
Linda Moore
And how do you know Mr. Bearden?
is my brat nephew.
Your brat nephew? So you have some fondness for him?
Mm-hmm.
All right. Where would he live if he was able to get a reduction in his bond?
At the house with me and my parents.
Okay, so he's welcome home with you?
Mhm.
And would you ensure that he attends all his court appearances and keeps up with me as his lawyer?
Yes, ma'am.
That's all the questions I have for you.
White, any questions?
No, Your Honor.
All right, ma'am, have a seat. Call your next witness.
Mr. Bearden?
I do.
All right, state your name for me.
Jonathan Michael Bearden,
And Mr. Bearden, how long have you lived in Bay County? Is
29 years.
that how old you are today?
That's my whole entire life, ma'am.
Okay. Now, we just heard from your aunt, and she's welcomed you into her home. Is that where you plan on going to live?
Full time.
All right. And what other family do you have here?
I've got grandparents, cousins, nephews, everybody.
Do you also have a daughter?
I do have a daughter. I have an 11-year-old daughter.
And where were you working before?
I was working at Marshall Brothers prior.
Do you have a job lined up?
Yes, ma'am, I do.
And where's that going to be?
It's gonna be with his Brad Hires. He don't actually have a business name yet, but it's a construction electrical work.
Okay. You feel confident that you've got employment if you get out?
Yes, ma'am, I have a Class A CDL and valid driver's license, transportation.
And are you able to post the $100,000 bond as it said?
No, ma'am, I am not.
And do you have a particular bond amount you think that you would be able to post?
Maybe if that 100,000 got reduced to maybe 25,000 or something of that nature.
I don't have any other questions, Your Honor.
Dwight, any questions?
No, Your Honor.
You call your next, state, you call your next witnesses. please.
No other witnesses, Your Honor.
State have any witnesses?
No, Your Honor.
All right. State's argument?
The state would object to any modification of the bond. The defendant is currently charged with a burglary with a battery, which is a punishable by life felony. He also has a previous conviction, 2 previous convictions for felony battery, and a previous burglary conviction.
Your Honor, the bond is too high for him to post. It's like being held without any kind of bond. He is able to post a $25,000 bond, which is a substantial bond, which would ensure his return to court. And he does have family and ties and a job out there, Your Honor. So we'd ask for the bond to be reduced to the $25,000.
I reviewed the probable cause affidavit and reviewed the information. He's charged with burglary with an assault, which is a first-degree felony punishable by life. I believe the $100,000 bond is a suitable bond for this offense. I'm going to leave it as it is. Do we need another court date, Mr. Bearden?
Yes, Your Honor, in April, so I can get depositions.
April 23rd at 9 o'clock.
Ashley, thank you for gifting the 10 memberships. I very much appreciate that. Again, always so generous to the channel, so thank you.
Your Honor, this is David Murray. His case number is 253827. We're here for a bond for ROR, pretrial release or reduction.
Call your first witness.
I call Mr. Murray. Always for the testimony you're about to give the truth.
Yes, ma'am.
All right, Mr. Murray, tell us your name.
David Murray,
How old are you today?
69,
All right, and how long have you lived in Bay County?
about 18, 19 years.
All right, you have family here?
I one family, my wife, Naomi Hatch.
All right, and you weren't working prior to your arrest, right?
No, I work at Pay Center,
Oh, you were? Okay.
a temporary service.
All right, were you also drawing Social Security already?
Yes, ma'am.
And are you able to post the bonds as they are currently set?
I guess I can, I believe I can.
You think you have 10,000 to post for count 1, 5,000 to post for count 2, 10,000 to post for count 3, 1,000 for count 4, and 2,000 for count 5?
No, ma'am.
No, okay. Do you have any money at all to your name that you could put to a bondsman to post bond?
No, ma'am.
If the judge were agreeable to let you out on your own recognizance, or to give you the pretrial release program where you call in once a week and they keep up with you, are you willing to do that?
Yes, ma'am.
And are you willing to come back to court and keep up with me as your lawyer?
Yes, ma'am.
I don't have any other questions, Your Honor.
White, any questions?
No, Your Honor.
You call your next witness.
That's the only witness, Your Honor.
State have any witnesses?
No, Your Honor.
What's your argument?
The state would object to any modification of the bond, given the nature of these charges. The bonds as they are currently set are fair, and the defendant has an extensive criminal record, including several prior thefts and several prior burglary convictions.
Ms. Beasley?
Your Honor, even though he has a long history, he's also 69 years old, and some of that history is ages ago. He does have ties to this community. He does have somewhere to go and live. He's been working part-time, and he's not a flight risk, Your Honor. So we asked for an ROR, or in the alternative, have him on the pretrial release program where he's calling in once a week.
All right, I've reviewed the probable cause affidavit as well as the information. I've considered his prior record and I guess everyone agrees it's extensive prior record. His ties to the community, however, his bond's only 21,000, 23,000. So based on the second degree felony and the 2 third-degree felonies, I believe that's a fair bond.
I've got 28,000 when I did the math, Your Honor. You got 23?
I agree with you. Is that it? I missed
Madam Clerk says it's 23, so I apologize.
23,000. Okay. All right. I'm gonna deny the motion for to reduction. I believe that 23,000 is a suitable bond. You want to set it for April 23rd?
Yes, Your Honor.
April 23rd at 9 o'clock.
Your Honor, I had Bradley Williams. Your Honor, this is Mr. Williams in case 241657. Dr. Rayleigh filed a report, I believe, yesterday on his case, and I've had an opportunity to review that and have no objection to the report.
I have not reviewed it. Let me review it.
Concurrent here.
All right. I reviewed the report. Dr. Rayleigh is opining that Mr. Williams has been restored to competency. And Ms. Beasley, you're not objecting to that?
No, Your Honor.
State wish to be heard?
No, Your Honor.
All right, I'll accept that report and find that Mr. Williams is competent to proceed if you prepare a simple order to that effect.
Yes, Your Honor. And we have a resolution in his case
Okay.
for misdemeanors, and I'm passing that plea form forward.
Okay. That's just a copy. You just, there's one in the file also. All right, good luck to you, Mr. Williams. I have approved the order. Good luck. Yes, sir.
I got Keandre Paul. Your Honor, Mr. Paul's coming down in case 253199. Dr. Rayleigh filed a report and benchmark that I was able to review this morning. I don't have any objection to the report and agree with it.
Let me read it. I've just one in the file. I have just got filed yesterday, or it got filed today, it looks like. I'm kind of at a loss on the evaluation. It seems that Dr. Rayleigh, unless I'm reading it incorrectly, is indicating that Mr. Paul is arrested on trespassing.
Well, he's got a burglary tools and resisting with violence. Oh, I'm sorry, that's the other guy.
He's got a battery on a law enforcement officer. So I'm not
He
sure.
also has a misdemeanor in misdemeanor court, 2 of them, 25 NM 3896, 25 NM 4373.
I don't care about those. What I'm worried about is
That could be the trespass then. Madam Clerk says one of those is a trespass, Your Honor.
I don't know what the doctor all it. At least acknowledge it is before the court on a felony. You got something worked out on this?
I'm sorry? No, Your Honor.
All right, since there's still nothing worked out, I'm gonna take this under advisement. And if is anybody object me reaching out to Dr. Rayleigh and inform that there's a felony pending instead of a misdemeanor trespass?
No objection, Your Honor.
We'll set it for March 27th at 9 o'clock and we'll go from there. Let's see, Summer, you ready? You got anybody?
All right, we've been there for a little bit. Let's switch it up. Let's go back to Michigan and Judge Elmore, where he's got people so worked up, apparently, that they're turned on their side.
In that file, appearances, please.
Good morning, Your Honor. Abigail McIntyre, appearing on behalf of the people, P71143. Good morning, Your Honor. Lisa Kirsch-Satala, appearing on behalf of Mr. Allen, who is present.
Thank you. Sir, you may be seated. Now, looking to the next file. People of the state of Michigan versus Wesley and Connor. This is file number 25-14162FH.
Good morning again, Your Honor. Abigail McIntyre, appearing on behalf of the people.
All right.
Oh,
Who is the defense?
I'm Jeff Harrison. I'm here on behalf of Miss Connor. As the court will note, she is not physically present. She is present by Zoom. I had a conversation with her this morning. She was in the hospital last night with some kind of sepsis related infection.
I got it. I don't need to know. What?
No,
Thank
there's
you.
no objection for the people that she.
All right.
Thank you.
Thank you. All right, so we're here today. Set for a final pretrial conference, it is. And I know we have a trial date set in about a couple weeks. We have a motion here. Let's go ahead and take care of the motion. The motion is to adjourn the trial in the Christopher Allen file
It's for the both,
and
both.
and Wesley Connor. Do we have them joined together for one trial? Do we?
We do, Your Honor.
No.
I don't know if Ms. Satawa is going to be filing a motion to sever,
Okay, right.
but that hasn't been filed yet, to my knowledge.
all right. So.
I actually have the draft with me, but so it will
We
be.
can make it orally, so we'll talk about that, or we'll see if we need to raise that up first. Then I also saw that there was an intent for 76827B information, and that was filed in the Wesley and Connor file.
That's correct.
Does that apply to both?
No, just applies to Ms. Connor.
Thank you. All right, so let's deal with the people's motion to adjourn the trial date.
Well, Your Honor, this is the second time that the people have brought it before the court. The first time the court informed the people that it was a premature motion, because I informed the court that I was double booked. I am booked to be in a trial on March 11th in the suit. That is also a capital case, which we scheduled back, I believe, in October. As far as today goes, we received a notice from the court in the Sioux that we are still on the docket, ready to go.
And that's why I don't like motions to adjourn until I know it's really gonna go to trial. And I often call the other judges and say, hey, judge, is this one really likely to go to trial? Give me your input. So I like to wait till we get to the end, because I don't wanna adjourn and lose a trial date here in our courts. All right. And in that case, you said capital, is the defendant still in probably confinement?
He is on house arrest and tether.
Okay.
It is an older case. It's two counts of CSC first, incapacitated individual, and one count of CSC third.
Okay.
There's been no offers, so
All right.
requested were made at this point. So it's my feeling that it's gonna go.
All right. Our trial here is set for March 10th. Is that correct, Madam Clerk?
Yeah.
All right, Ms. Satawa, your response to the motion to adjourn?
Your Honor, we have no objection to the request to adjourn. We have been in the process of getting our experts report. It has not been, we don't have it yet, and we have obviously not been able to turn it over to the people. In addition to that, we have been having some fruitful discussions, and so we're hoping for more time.
All right, sounds good, thank you. Well, again, it wasn't intended to be rude when I denied the stipulated request. It's just because I want to make sure I keep cases moving. This also gives me the opportunity to talk to the defendants in person and hear from the judge. My goal is to get the case moving, get the case done. However, when there is a reasonable, good cause request to adjourn a trial, then I'll grant it. There are also things that put other cases forward versus others. And since neither you or Ms. Connors are in pretrial custody, your case is not the top. So I'm going to go ahead and grant the motion to adjourn. We'll have it reset on the trial docket. There will be another final pretrial conference. All right, so to both Mr. I always want to, there's another case that has a very similar name, and I don't want to call you that person's name, and Mr. Allen. So Mr. Allen and Ms. Connor, when I have final pretrial conferences, final pretrial conferences are the last date in which we're going to take, or I will allow an acceptance of a plea underneath the pretrial agreement. And then if we don't have one on a final pretrial conference date, then the case is going to trial. The only thing I'd let you do is plead straight up on the trial date. Now, please know, Mr. Allen and Ms. Connor, that is not to force anybody to enter into a pretrial agreement. In fact, my policy, I think, helps defendants just as much as it does me. You want to know on that day, is the offer going to get any better? And the answer is no. I don't want you waiting till the very last minute, freaking out and, oh my gosh, am I gonna get this? You know, on that day, that's the best offer that people are going to give to you. And also because there are a lot of things that have to happen in the background. You have to have about 120 potential jurors come in. They all have to rearrange their schedules, get somebody to pick up mom, take grandma to the hospital, take care of the kids, get somebody to stay home from work so the other spouse can come. And all that. Plus subpoenas have to be issued, witnesses have to be brought here, and there's a lot of moving parts. So before I make those parts move, I tell the attorneys, make sure you have exhausted all your brilliant negotiating skills and tactics. That again, not only helps you, but also helps the court. And on average, I can do about 24 trials in a given year covering 2 counties with circuit court criminal cases. And if I were to allow deals on the trial date, I'd lose the opportunity to do a trial. And therefore, the people of Wexford and Missaukee County lose a trial date too. So please know, I don't know anything else about the file other than the charges. I have no opinions about what you should do or how the case should resolve. I'm just here, I run Tiger Stadium, also known as the circuit court, and I want to watch somebody play baseball that day, okay? Which is always the funniest analogy for me to give, because I cannot stand baseball. All right, thank you. All right, so on that file, we've covered the motions to adjourn. There is something else, and do you want to talk about joinder or severance, or do you think you want to put together a written motion to put it all together in a better package? I don't particularly care.
I mean, I can argue it off of my draft if the court wants to hear it.
But it all, and now that means I turn to Ms. McIntyre and say, because I know you have the right to have notice. So
Your Honor, honestly, it would be my preference if it were written, and so I have an opportunity to respond.
Sure, I don't
And
know.
I mean, depending on what she says, I don't know what my answer is gonna be. I mean,
Okay.
Ms. Satawa could make a, really brilliant argument, and I could say, makes sense. So,
Well, if there's anyone who can, it's probably Ms. Satawa.
so I would prefer written, Your
No
Honor.
problem, that's fine. And who knows, maybe in the preparation of that and exchanges, you all might go, oh my gosh, that makes sense, or maybe it'll help resolve the case. So it's probably best that I don't address it now. But I wanted to make sure that the counsel, the attorneys, and that's right, parties that heard us talk about that a little bit. Again, I think it's the first time I've met you, Ms. Connor and Mr. Allen. Maybe I'm wrong, but I think it is. If I haven't, that's a good thing if I don't recognize you. Right? All right. Good. All right, anything else you think we need to address, Ms. Satawa, today?
No, Your Honor.
All right, Mr. Harrison, on your file?
I'm fine as well. Your Honor.
All right, thank you. I forgot to ask you, Ms. Connor, are you able to see and hear us today?
Yes, Your Honor.
Hey, I don't want to turn this way since you're signing. All right, Ms. Connor, hope you're feeling better. We'll see you all in a couple weeks whenever I get a new docket schedule. Anything else, Ms. McIntyre?
Your Honor, just for clarification, because I'm a rookie in front of your court, so the court is gonna give us another pre-trial date without a jury trial date. The jury trial date will be determined at that pre-trial date.
Nope, you will get both. You'll get a date for both.
Okay,
And then we'll deal with, potential adjournment, things like that if we need it.
potential conflicts again.
It'll probably, you won't be back here till at least probably a month for a final pre-trial date on a Friday.
Okay, I just was wondering in terms of a trial date, like if there can be, well, I don't know how the court schedules it, if there's like emails that go out and say, do these dates work? Because I know there's other trials that have been scheduled, and I also
Yeah.
have some medical issues going on that have to be dealt with, so.
Okay. All right, well, the answer is I just pick dates.
Okay. Yeah,
Because if I ever try to coordinate dates,
I know it's a circus.
and especially, and I see it with my civil cases, it takes forever, and I'm just not going to do it.
Okay, fair enough.
Yes, ma'am.
I am 100% not available from April 28th to May 13th.
Maybe, hold on.
I can send an
Okay.
email.
Yeah,
and
just do that to Nicole. Nicole's the one that handles that. So that's perfectly fine.
Okay.
Going someplace fun?
South Africa.
Oh, well, can we all go?
I don't know. Well, anyway, that's fair and reasonable, but if you guys have a good excuse, that's fine. And again, if I just keep the things going, sometimes a case resolves and I keep you all thinking about it. I do not like cases slipping on to the back burner. And I know you both or you all are quite busy. So we'll see, we'll deal with it. Send a message to Nicole. And she'll take that in consideration, setting it out, as long as there's no objection. All right, thank you, folks.
Thank you, Judge.
We're adjourned.
Okie dokie. Let's stay in Michigan. Let's go back to Judge Flores, see what's going on.
Ms. McCollum.
Morning, Your Honor. Natalie Macomber on behalf of the people.
Mr. Doyle.
May it please the court, Dan Doyle appearing on behalf of Antonio Whiten, and he's appearing via Zoom.
And sir, you are Antonio Whiting Jr., is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Whiting?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. Sorry, it's my understanding that defense will be asking for an adjournment in this matter and waiving there were 21 days to hold the exam. People will not oppose that adjournment request.
All right. And is that a fair statement, Mr. Doyle? You'll be requesting an adjournment and a waiver of the 21-day rule.
That is correct, Your Honor.
May I inquire of your client, Mr. Whiting, of his waiver of the 21-day rule?
Yes, Your Honor.
Okay. Mr. Whiting, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by Attorney Dan Doyle, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a prelim within the 21 days. 21 days. You wouldn't be waiving your right to a prelim in general, just within the 21-day period. So negotiations continue between the parties. Is it your wish today to waive your right to a prelim within the 21 days?
Yes, Your Honor.
And do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
I find that the waiver of the prelim of the prelim within 21 days to be knowing, voluntarily, and accurately made. And then where did you want this reset? What
I would leave that to Mr. Doyle's discretion. I did briefly talk to him about potentially setting it for the same day as the other exam and maybe doing it a little bit earlier. He did not think that was the best idea as far as making sure everything lines up.
Right, and I don't know Mr. Doyle's schedule, so.
I'll leave it up to him.
Yes, Your Honor. Sometime toward the end of March or early April would be fine.
All right, we set the other prelim for March 27th at 1:30, but I don't know if that date works. That's when we set the other. We had the prelim yesterday, so I kind of remember. But I think we have 3 witnesses left, and we have 2 witnesses left, and one's on the stand.
Yes, Your Honor.
Okay.
Right. I don't think it's necessary to have it that same day.
All right.
Following week.
All right. So if we can do it, let's look at I don't know if it's Thursday or Friday, Megan.
It'd be a Thursday.
So the following,
It's a Friday. So
it'd be April 2nd.
second, maybe.
April 2nd would be the following Thursday that's set for prelims. Does that date work for you, April 2nd?
It does, Your Honor.
Okay.
Does morning or afternoon, do you have a preference?
Do you have a preference as to morning or afternoon?
No, Your Honor.
Do you have a preference, Mr. McComber? Okay. Let's set it for April 2nd.
At 8:30?
At 8:30. So we'll set it for a preliminary examination for April 2nd at 8:30, and then we'll go from there. And at that time, the co-defendants in the case, we should know what's going on in that matter after that prelim, which will be the week before.
Yes,
All right. Anything else for the record in docket 26-00156, Ms. Maycomer?
No, Your Honor.
Mr. Doyle?
No, Your Honor. Thank you.
All right, Mr. Whiting, we will be live on the 6th floor of City Hall of Lansing on April 2nd at 8:30. All right, sir?
All right, thank you, Your Honor.
All right.
Have a nice-
You should be all set. Thank you for your appearance today.
All
Thank
right.
you. Ms. Fortuna Gill,
Yes, sorry,
are
Your
you ready
Honor.
on
We
Mr. Radcliffe?
Yes.
All right. We'll see you soon, Ms. McComber.
Yeah. No.
All right, so we are on the record in docket 25-02415. That is people of the state of Michigan versus Toby Radcliffe. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Radcliffe, who is standing to my right.
And sir, you are Toby Radcliffe, is that correct?
Good morning, Your Honor, yes.
Thank you. This is the time set for a sentencing in the matter. Ms. Fortuna Gill, do you know of any further restitution or any restitution in this matter?
No restitution, Your Honor.
All right, thank you. Mr. Goodrich, have you had the opportunity to go through the pre-sentence report with your client?
Yes, I have, Your Honor.
Any additions, deletions, or corrections?
The one correction I'd like to make is under employment data on the risk scoring, personal history and impression session. He is now employed.
All right.
He's working for a guy named Sam maintaining rental properties.
All right, with that correction. Anything else, any further corrections, deletions, or additions?
No, Your Honor.
All right. All right, allocution, Mr. Goodrich.
Thank you, Your Honor. Your Honor, Mr. Radcliffe has a lot of difficulties that he needs to overcome in his life. He's been homeless and unemployed for much of his time while this case has been ongoing. However, as I just informed the court, he's recently gotten a good job with a guy he trusts. He's working full time now, maintaining rental properties, managing those type of things, fixing problems with those. He hasn't got his paycheck yet for that because he just started a week or two ago, but that should be coming in. I would ask the court to consider limiting drug testing for the sake that he doesn't have a lot of money to start with. Hopefully it'll be better as it goes along. I called him this morning. He assured me he was coming to court. His vehicle broke down on Pennsylvania. He walked the rest of the way here because this is something that he considers important. He's been working with CMH because he has mental health issues as well. At CMH, he's been doing therapy to address some of the issues that make him turn to meth. And he's also been doing drug counseling as well there. I would ask the court to essentially kind of have him continue that. And also, he's been on tether since he got released last time. I would just ask the court to not continue that as part of probation, as I know it's causing him a lot of pain in the leg and such. So we would ask the court to generally follow the recommendations in this matters. I think Mr. Radcliffe is making a lot of positive steps, Your Honor, and I'm hoping he can get on a track where we don't see him again here.
Right. There does seem to be some restitution in the file because there's a pink sheet. I want to make sure we're on the. I have $1,500 restitution. Does that seem?
Your Honor, if I may, it's from my previous charge for the failure to return rental property.
Oh, okay. All right.
Did we dismiss the case as part of that?
Yeah,
it was a plea to count 3 of use of controlled substance I have, and then the agreement to pay restitution of $1,500.
Yeah, that's for that's right.
That's for the other charge.
Yeah, I'm still trying to find it, Your Honor. I've been all over Howell and I can't.
Yes, Your Honor, just for the record, on file 25-2852 FY, that case was dismissed as part of a plea agreement in this case.
Okay.
And that must be where that comes from.
Right. That's the only thing I was wondering about. Mr. Radcliffe, is there anything you'd like to say to the court before the court passes sentence?
Other than I just appreciate the opportunity to be put on probation to correct a problem that I've been struggling with for a long time. I guess you could say the motivational kick in the butt is kind of what I need sometimes. it's part of, my mental health problem. I'm doing everything I can right now, and I'm more than willing to comply with the courts.
All right. Ms. Fortuna Gill, is there anything you'd like to say to the court before the court passes sentence on behalf of the people?
No, Your Honor. The people would just request that the court follow the recommendation.
All right. All right, so I'm going to, so there's a count 2 here too. An added count 3. Okay, so this is for a guilty plea on October 23rd, 2025. This is an added count 2 of weapons, firearms, improper possession in or upon a motor vehicle and use of controlled substance. I'll follow the recommendation as indicated. So the defendant is to spend 365 days in jail. Credit for 83 days. I'll suspend the remaining 282 days as a condition of probation. So you don't have to do that. There'll be no upfront jail, but you'll be placed on probation. So on count two, sure. The fines and costs will be $50 fine, $50 costs, crime victims' rights fee of $75. I'll waive the state fee. As a part of this agreement, there's also a $1,500 restitution that I'll write in order, but that will be, so on count 2, which is the weapons, firearm, improper possession, it'll be $175, 50, 50, 75, $175. And then on count 3, which is the use of a controlled substance, methamphetamine, we'll set fines and costs at $150 fine, $150 cost, crime victims' rights fee of $150. State fee, I won't waive that for $50. So $450. I think I have that $500. $300, $450, $500. We're putting on probation. Oh, and that changes too because we're putting on probation. So probation will be placed for, on count 3, probation will be for 12 months as requested. 12 months probation at $30 a month. So that'll be 300, 360, is that 360?
Yeah.
So $860 is the total on that charge. So you're placed on probation. The other one is, what is count 2? Is that weapons or firearm improper? Is that a 90-day or is that a 1?
It's a 90-day.
It's a 90-day. So I'm not gonna order. I'll order 3 months. I'll order 3 months probation on that. He's already done that time. He's done 83 days, so it's a 90-day. I'm not gonna order probation on that. So probation will be on the second charge, which is the 1 year. And I won't order probation on count 2, just for the record. So the plan is to put it all on count 3, and that's $860 on 12 months. So probation is set for 12 months. There's restitution on another file.
It's impeding traffic, Your Honor.
No, that's not.
Yeah, that's
$1,500.
that was on file 250. Oh, I see that. That's the actual file that the restitution was ordered on. That's a separate file that was dismissed.
That is correct, Your Honor.
All right. So restitution for $1,500 on file. Is it 25? Give me the file number.
Yeah, absolutely.
Just so I can't read my writing.
Of course. It's 25-02415 FY.
That's the current case.
What?
Yeah, that's the current case.
Yeah,
Well, then I wrote down the current case number when I was.
So this, is that the
I can get-
2508?
I have 2852 on the
That-
larceny of
that's-
rental property.
That looks like the
Thank you.
25.
Well, it's.
Yes, it's 02852. That is correct.
082. What do you?
It's 25-02852 FY.
082. All right. All right, so on file 25-02852, restitutions to be made for $1,500 as a part of this, probation for 12 months at $30 a month.
Paying 30 a month or 60.
There's no assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance. I will have submit to random PBTs and your analysis as directed by your probation agent, but with the understanding that that may be lesser as you get back on your feet. And Mr. Radcliffe, I've taken a look at your criminal history, and you're mounting some criminal history here.
Oh, I understand.
So if there's a problem with methamphetamine, or which may be the case, may not be the case, but we need to know about it so we can address it. All right. So no bars or nightclubs.
Yeah.
Submit to random people, no bars or nightclubs. I have not purchased or possessed any firearms, ammunitions, or weapons of any kind during the term of probation. And obtain and maintain employment, and that's already been taken care of. So really, it really, as far as any additional follow-up, there is a, have you been in contact? There is some indication that you've been in contact with community mental health. Is that a part of, have you been doing that?
Yes, I've been going twice a week.
Okay.
So I have to transfer though, because I'm not in Eaton County anymore. So I just did my last 2 meetings with my counselor, so I've got to find a new therapist in Eaton County.
Okay, so I'm gonna order that be a part of this probation. And so you may have to sign something for the probation agent so they get it, but so I'm gonna order that community mental health and treatment at the discretion of Mr. Hannah. I know Mr. Hannah, and Mr. Hannah is a pretty easy person to work with.
Yeah, he seems really nice.
Yeah, he's a pretty easy person to work with. So if you provide him with any access, we'll just make sure to monitor it, whatever you're doing with community mental health, okay? All right. So that 1,500 on the separate file, the 12 months probation is put on count 3. Count two is the 90-day storage charge. So, Ms. Radcliffe, you know how this works. The less we see of each other, the better. Okay, I mean that's how it works. If you end up getting violated, then you're in here, and that doesn't work for it. Doesn't work for you. You must have better things to do on your time than a Friday morning spend time with me.
Absolutely.
Yeah. So, yeah, that's so true. All right. Any questions concerning the judgment of sentence, Ms. Fortuna Gill?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor.
All right, the probation is 1-4 down, so I believe it's non-reporting. I think he had Zoom reporting.
I don't have a phone right now, Your Honor, so would it be possible for me to do in person?
Yeah, what you should do is go down to the 5th floor and just make sure that Mr. Hannah knows that you don't have a phone. And so any reporting can be done in person until you're able to do it via Zoom, all right? All right, just to make sure you're on the same page. Anything else for the record in 25-02415, Mr. Goodrich?
No, Your Honor.
All right, Mr. Radcliffe, good luck to you. Okay, sir?
Thank you.
Thank you.
I'm gonna talk to you in the hall for just a minute. Okay.
All right.
I'm gonna make this look all pretty, okay? Because they're gonna, because I wrote all over it, so. That'll go to probation. Mr. Goodrich, you've been busy also. I know that.
In the LPD, it looks like.
Yeah, I haven't been here. I don't think I've seen you since before Christmas.
I know, and you've been in trial,
Yeah.
and so, you know, just,
I was here a little bit in early January, and then I've been gone for a month.
yes, so it's nice to see you.
See you.
Have a good weekend.
All right, and you have not spoken with Mr. Schmidt.
I have not spoken with Mr. Schmidt. I think that he doesn't have defense counsel because he's
Alright.
been in MGOC.
All right. So if you want, you can talk, is this a felony or a misdemeanor?
This is a felony. Right? It's an RNC section.
Yeah, yeah.
Megan, should I just take him downstairs, or do you have any paperwork he needs? Or?
I just have to take his file down, but Judge is still writing. I think he's gonna redo the.
I'm gonna redo the JOS just to make it look.
But he can just head down there.
All right, so we're on the record in 26-00036. That is People of the State of Michigan versus Zachary Schmidt. This is set for probable cause conference today. Make sure that we've done the writ for next week, February 27th at 9 a.m. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
And sir, you are Zachary Schmidt, is that correct?
Yes, Your Honor.
Right, thank you. This is the time set for a probable cause conference. Mr. Schmidt, you are not represented by counsel, is that correct?
I have a lawyer. I'm just waiting for the money to clear.
All right, what's the name of the attorney, sir?
I think her name's Miss Dubrul or something like that.
All right, I'm gonna assume that once the money clears, this is set for next week. We can just leave on for prelim. We already have done the writ, so the writ's already been done. And we'll show we can see who shows up next week and go from there. Unless you have a better idea, Ms. Fortuna Gill.
That sounds fine to me, Your Honor.
Okay. All right, so Mr. Schmidt, you're waiting for to retain representation for the money to clear, but we're gonna writ you out for next week. So we've had the probable cause conference and the preliminary examination is set for February 27th at 9 a.m. If the money money comes through, tell your attorney, Ms. Brule, to file an appearance so she can get any discovery in the matter. Okay, sir?
All right, thank you.
And the assistant prosecutor will be here for Ms. Brule to talk to. But we should we'll writ you out. You should be writ out on February 27th at 9 o'clock. All right, and we've done the writ. All right,
Well,
so Mr. Schmidt, we'll see you next week on the 27th.
All right, will it be over Zoom again or will I come to
No,
Lansing?
we'll see you live. We'll see you live in person. They'll come and they'll transfer you out.
All right, thank you.
Okay. Anything else for the record in 26-00036, Ms. Fortuna Gill?
Not for the people, thank you.
Mr. Schmidt, do you have any further questions of me?
You said that was the 27th?
It'll be next Friday at 9.
All right, thank you.
Thank you. You should be all set. Thank you for your appearance today. You're all set, Mr. Schmidt.
All right, have a good day, Your Honor.
You too.
Okie dokie. Let's go back down to Florida, check back in with Brantley Clark.
Mr. Taylor, Mr. Shepherd, has filed a motion to withdraw. Any objection? All right, are you gonna hire another attorney?
Or I gotta get court-appointed lawyers, sir.
All right, what I'm gonna do is I'll grant the motion. And then I'm gonna have, you have a seat and then fill out a, affidavit, okay?
Your Honor, I also have Christopher Carell. I'm not sure. I know Mr. Sullivan had talked about continuing that one. The last time I looked, I didn't see where he had, but it may have been continued. And that's 25 or 232795.
That's set for trial. Is this a trial manager? What is the day? We got a motion to suppress?
Yes, Your Honor.
Has that been heard yet?
I'm sorry, Your Honor.
Is the motion to suppress been heard?
I believe it has. Let me take a look.
So this is the.
And this one is set for trial March 2nd, Your Honor. This past week, the state disclosed 3 additional witnesses. We have spoken with.
Motions were set for today too.
Yes, Your Honor.
So that I don't think the motion to suppress has been heard.
I don't think that it has actually, now that I think about it.
Okay.
But so, but I had spoken with Mr. Sullivan earlier this week and he told me that it was his intention to continue it.
All right, any objection?
No, Your Honor.
Okay. I don't want to put it back on the trial docket until we have the motion suppressed and also, so I wonder if we can do anything March 27th or we need to set it for April motion day.
I would probably, I think that April would probably be best, just because when we've spoken to, I can't remember her name escapes me, but the lady who helps to set up deposition dates, she had said that we wouldn't be able to get one before the current trial date, so I don't even know.
This April 24th at 9 o'clock for the motion to suppress and anything else, and we'll set a hearing after that. And set a trial after that if we need to.
You said the 24th, Your Honor?
Yes, ma'am.
Okay. I also have David Murphy, and that's 2020-04-569. And Your Honor, we had filed a motion to dismiss in this one. That to my knowledge, the state hasn't filed a traverse to.
I apologize. I don't know anything about that. I have my instructions here. I'm not sure. But I believe his plan is to traverse it because he told me to keep it on the trial docket. So.
Does Mr. Murphy have other cases too?
He does, Your Honor. Thank you.
Which one is, this is not, is this the one that's on the trial docket? The drugs? I would think that would be the one that's they're the most serious charges, aren't they?
That's correct, Your Honor. And that one is, excuse me, that one is currently set for March 2nd.
Okay. We're gonna leave that on the trial docket. I'll reserve on this.
Sure.
And if
I'll get with Mr. Sullivan for answer there.
if there's a traverse being filed, if not,
Mr. Sullivan wanted me to communicate that on the trial docket, he is attempting his best to make sure that he can get all of his witnesses here. So he would like to leave it on the trial docket with the understanding that if there are issues with the witnesses, he may have to do something.
well, I hope he can do it because this case is old. It would be my intention of trying Mr. Murphy that week. Okay?
Yes.
All right.
And then, Your Honor, I think that's it for the morning. We have 2
Yeah, go ahead and call
short
it in.
trial managements for this afternoon.
Oh.
The first of those is Amanda Nichols. That's 22-5105. That one's also set for the March 2nd docket. Or, I'm sorry, for trial.
Mr. White?
My knowledge, I don't know that we have the ability to try this case on the March 2nd docket, so we could set it off for April.
Any objection?
Yes, Your Honor. I think this is probably the 5th time the state has continued.
22, it's a 2020. Have you got subpoenas out?
I do not, Your Honor.
Let's see what we can do. I mean, it's a 2022 case. I know it's out of custody. I know it's a grand theft scheme to defraud, but
And Your Honor, if I could, the original charges for this one, there were 3. 2 of them they've already dropped because they were unsubstantiated. The third one, from everything that we can tell, is also unsubstantiated. This is and has severely impacted her livelihood because of these pending charges. I think it would be a quick one-day trial. We would vehemently, again, object to any kind of continuation in this case, and I have communicated that to Mr. White before today.
all right. I'm gonna leave it on the docket, March 2nd.
And let me just check real quick, Your Honor, make sure I don't have anything else. Oh, yes, and stall. That's also on the PM docket.
Okay.
And that one is set for the March 2nd week for trial as well.
All right. All right, we'll leave it on that docket.
And Your Honor, I think we still have a motion pending for that one. I don't think we've.
There's a motion, there's a motion to dismiss.
Yes, Your Honor.
State and the defense is. Nobody's noticed it, looks like.
I believe, Your Honor, Mr. Shepherd handled the hearing for that one. And so I think that the intention was for today, or was at least to kind of see where we are on that. I'm not sure if the state filed a traverse to that one either.
They filed a response.
They did. Okay.
One done in writing back and forth. I don't know that there was an actual.
That's correct.
That's correct. I think that's this one.
It is.
Oh, well, yeah, okay. All right, I'll get you an order. I'll get you an order in the next week.
Okay, thank you, Your Honor. And that is all I have.
Meredith? Miss Nelson, see if Miss Brown is on the docket, or if she's going to be on the docket. Miss Balthasar is present. She's from the Sparta State Hospital. I haven't seen Miss Brown. We need to go ahead and see if she's what she's going to do. Who is this? I'm sorry.
This is Eric Smitherman.
Smitherman.
He was arraigned Monday on case 26044. There's a bond of $1,000 set in that case, so we're not arguing that. He's scheduled for a bond reduction in case 26380, which is scheduled for arraignment in March.
Okay.
He is charged with 5 counts of similar failure to register. In each count, the first appearance judge set a $15,000 bond. They are third-degree felonies. Mr. Smitherman's from Bay County, has family and ties. We would ask to be reduced, I think, $5,000 per count. He'll be able to make that, and he will show up for court. Yeah. $1,000 was a gift.
Response.
They would object to any modification of the bond, Your Honor.
Is there any other charges other than the failure to register?
No, Your Honor.
Is any other investigations ongoing?
Not that I'm aware of, Your Honor.
I think the allegations all relate to one device.
Well, there's allegations of sexual battery.
Well, that was what they were
But
they were talking to him about, but
that ain't going anywhere.
no, sir.
What I'll do is, I'll grant the motion and I will set it on the case number 26 CF 380. I'll set it at $1,500 a piece. $7,500. Is that my math? Madam Clerk, you want to check my math again?
That's correct.
All right, $7,500. And they will leave them on that arraignment docket.
Yes, sir. So if you get out, I mean, you still have to come back. 7,500 plus you got to post 1,000 again. Okay. And Your Honor, on the afternoon, I have Jeremiah Black.
Yes, sir.
And Judge, we're scheduled for trial on March 2nd. Mr. White said
Other shoulder.
this would go. I don't know if that's changed now that.
What?
The state would like to leave this on the trial docket.
We'll leave it on the docket. We'll see you that day, sir.
All right. I was asking for a request of some paperwork from my attorney of the pay. He said that there was no confidential informant. It's been like 3.5 years, and even he said there's the four corners was supposed to be presented, but there was no written agreement, even on a confidential informant, to no paperwork to be presented to me so I can give to a lawyer or anything. He said everything was gonna be all right, and it's been almost 4 years now. I'm trying to get my daughters, you know what I'm
I have no
saying?
idea what you're talking about. Absolutely no idea. We'll see you March 2nd at 8:30.
I understand.
That's for March 2nd at 8:30.
Yes, sir. I was just requesting for some.
March 2nd at 8:30.
He's got an appointment Tuesday afternoon. I'll try to explain again.
All right, we'll see you. Sign a notice. Leave.
Appreciate it.
Judge Brantley's had enough of him. Let's go back to Mindy Glazer. We're creeping up on lunchtime. Let's see how she's holding up.
Spanish. Good morning. So there's two misdemeanors charged here. He'll appear on the PM calendar today.
Okay. Good morning, sir. You were arrested for possession of a stolen or fictitious driver's license by an unauthorized alien and fleeing and eluding a police officer.
Buenos días, señor. Usted ha sido arrestado por los cargos que se le imputan, la tenencia de una licencia de conducir que ha sido robada por un inmigrante ilegal y también huyendo y eludiendo a un policía.
I will appoint the public defender's office for you, and also you have an immigration hold.
Si voy a nombrar a la Defensoría Pública para que lo represente a usted, señor. Además de eso, usted tiene una orden de retención por inmigración.
I think there's just probable cause for count 1, possession of a stolen or fictitious driver's license, a 3rd-degree felony.
Okay, sí, creo que hay motivo fundado para la tenencia de una licencia de conducir robada o ficticia. Eso es delito mayor de 3er grado.
The bond is $2,500, count 1.
La fianza son $2,500 para el cargo número 1.
Count 2, there is probable cause for fleeing and eluding a police officer.
Cargo número 2, existe motivo fundado para huir y eludir a un agente de la policía.
At a high rate of speed, which is a 2nd-degree felony.
A una alta tasa de velocidad, eso es delito mayor de 2º grado.
State you want that bond at $5,000 or $2,500?
$5,000.
$5,000 bond, count 2.
Y entonces le pregunta a Fiscalía, ¿cómo lo quiere? ¿5,000 o 2,500 la fianza? Dice $5,000. $5,000 queda fianza.
No driving unless you have a valid license.
No puede manejar salvo que tenga una licencia válida de conducir.
Next we have Alejandro Lizzo, page 9.
Bond out.
Thank you. Raul Chavez Galvan. Good morning, Mr. Galvan. You were arrested for 4 counts of trafficking in cocaine, one count of another count of trafficking in cocaine.
Buenos días, señor. Usted ha sido hoy arrestado, imputado el cargo. 4 cargos de tráfico en cocaína. Otro cargo también de tráfico en cocaína.
Possession of a place for purposes of trafficking in cocaine.
En la posesión o tenencia de un lugar con el propósito de hacer tráfico en cocaína.
An unlawful use of a communications device.
Y la utilización ilegal de un artículo de comunicación.
Sir, can you afford to hire a private lawyer?
Señor, ¿usted puede pagarse los servicios de un abogado privado? ¿Usted puede pagarlo?
Voy a intentar.
I'm going to try to.
Well, do you own your home?
Do you own your home? ¿Usted es dueño de su propia casa, señor?
No, no.
Do you have any money that can
No.
be used to hire a private lawyer?
¿Tiene algún dinero que usted puede utilizar para contratar un abogado privado?
Dependiendo de lo que cueste.
The interpreter could not hear well.
Can you
Can you
repeat
get
it,
closer
please?
to? Por favor, repita.
Dependiendo de lo que cueste. Wow.
I'm sorry, I apologize, but
No
the
switching.
communications is choppy.
No switching.
Más cerca, por favor.
Dependiendo de lo que cueste el abogado.
Okay, depending on what it would cost the lawyer.
How much money do you have saved up that you could use to pay for a lawyer?
¿Cuánto dinero tiene usted ahorrado que pudiera utilizar para pagar un abogado usted?
No, dinero mío no, tengo que pedirle a la familia.
No, I don't have any money. I would have to ask my family for that.
I will appoint the public defender's office for you.
Sí, voy a nombrarle la Defensoría Pública para que lo represente, señor.
So it's 4 sales to a CI, 2 for 55 grams, 1 for 30, another for 29 grams.
Entonces, son 4 ventas a un encubierto, uno por 55, las ventas, otro por 30 y otro por 29.
And then there's a search warrant where they recovered 555 grams. So that's a 15-year minimum mandatory.
Y entonces con la orden de captura consiguieron 555 gramos, entonces sería, excuse me, how much would be the state?
A 15-year minimum mandatory.
Mandatory. 15 años mínimo exigido, señor.
Okay.
Okay.
Anything you want to say, Ms. Corey?
Not at this time, Judge.
Entonces le pregunta a la Defensoría si quiere decir algo, dice no, en este momento no.
There is probable cause for all of the charges.
Existe motivo fundado para todos los cargos que se le imputan.
Count 1 through 4, the bond will be $15,000 each count.
Okay. Cargo 1 al 4 serían $15,000 cada uno de los cargos.
What do you want for count 5? $100,000?
Yes, with Nebbia.
Ok, entonces pregunta, y para el cargo número 5, quieren $100,000 de fianza ahí y con lo que llaman una retención Nebbia para comprobar la legalidad de los
Very
fondos.
well. So count 1 through 4, trafficking in cocaine is $15,000 bond each count.
Entonces, cargo 1 al 4, $15,000 de fianza cada uno de esos cargos, que es tráfico en cocaína.
Count 5, trafficking in cocaine for the stash found at his home. It was over 555 grams of cocaine. That will be $100,000 bond.
Y entonces el cargo número 5, que fue lo que se encontró en la caleta en su casa, que tenía 555 gramos de cocaína, esos son $100,000 de fianza ahí.
Count 6, possession of a place for purposes of trafficking in a controlled substance is $2,500.
Cargo número 6, la tenencia de un lugar con el propósito de llevar a cabo el tráfico en cocaína, esos son $2,500.
And count 7, unlawful use of a communications device is $2,500.
Entonces, cargo número 6, el uso ilegal de un artículo de comunicación son $2,500 de fianza.
All right, so you're going to have to, plus a Nebbia requirement, you're going to have to show that the money used to post your bond is from a legitimate source of funds.
Entonces, señor, además de eso está el requisito Nebbia, que significa que usted va a tener que mostrar que hay la procedencia legal del dinero que usted utiliza para fijar su fianza.
All right, have a nice day.
Tenga buen día.
Next, we have Jalen Davis. Somebody's here for him. We
Disruptive.
finally got to it.
Disruptive, Judge.
He was disruptive, so he isn't here. I guess it'll be in the afternoon.
While they bring up the next contestant, Great Granny. I just sent you an email to that Outlook address you used over at Buy Me a Coffee, so when you have a moment, check that out. No hurry. Well, as compelling as silence and non-complaining can be from Mindy Glazer, let's move on. Michigan Judge Mom.
About to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, thank you. You may proceed on the warrant.
On February 18th, 2026, at approximately 3:43 in the morning, Officer Bro and Officer Sloan were dispatched to 2215 10th Street for malicious destruction of property in progress. Officers were advised that a female was in the caller's backyard striking their vehicle with a baseball bat. Officers were then advised that the female fled in a gold-colored sedan, last seen northbound on Electric from Walnut. Officer Bro and Officer Sloan arrived at 2215 15th Street and spoke with the caller/witness, Jill Sotheby, Plano. She explained that she observed Becky Rose striking David Hasselback's 2017 Chevy Silverado with a baseball bat, causing damage to the hood, driver's side front and rear doors, driver's side rear fender, broke off the passenger side headlight, broke the driver's side door handle, and put multiple scrapes on the front driver's side window. Sotheby Polano further explained that she and Hasselback were sleeping when she woke up by a loud bang coming from the driveway. This is when she looked at the bedroom window and observed Rose striking Hasselback's vehicle. Rose was leaving the backyard to speak with Sotheby Polano, but when she realized she was on the phone with the police, she fled in her vehicle in an unknown direction. Hasselback explained to officers that he and Rose were in a former relationship and ended a few days ago, and this is probably the reason for her to damage his vehicle. Sotheby Polano has a camera facing a driveway and it captured the incident. Officer Saltzman responded to the call as well. He had prior knowledge of Rose in the vehicle that she drives. As Officer Saltzman was approaching Cedar and Electric Avenue, he observed an older gold Chevy Impala turn westbound onto Cedar Street from Cora Street. Officer Saltzman drove past the vehicle and observed a white female with brown hair sitting in the driver's seat as a sole occupant. At the same time, the caller told Officer Bro that the female left in a Dodge Neon. So Officer Saltzman disregarded the Chevy Impala and continued looking for a Dodge Neon. Moments later, Lincoln Park Police Officer Wilson, badge number 2634, operating Patrol Unit 4A, advised they were attempting to catch up to a gold Chevy Impala with Michigan registration 9 Nancy Victor George 22, traveling northbound on 4th Street near Emmons. Officer Saltzman advised that this was the same vehicle that he just observed and he would like it stopped. Officer Wilson initiated traffic stop on the vehicle on 4th Street near Riverbank. Officer Saltzman made the scene and identified the driver in the vehicle as the same that he had seen near Cedar Street and Cora Street. The driver of the vehicle was identified as Rose, and she was taken into custody by Officer Saltzman for NDOP. During his interactions with Rose, Officer Saltzman observed her eyes to be bloodshot and glossy, and he also detected a strong odor of intoxicants coming from her person. So he requested her to submit to a standardized field sobriety test, which she did. After performing the SFSTs, Officer Saltzman read Rose her preliminary breath test rights, which she agreed to submit to. Officer Saltzman administered a test and received a result of 0.34% BAC. He explained to Rose that she was under arrest for NDOP and OWI. While conducting an inventory search of the vehicle, Officer Smith located a wooden bat in the passenger seat of the vehicle. Officer Saltzman, while checking Rose's purse, located several containers containing pills. In a silver metal circular container, he located one white oval-shaped pill labeled M366. He identified this pill as a hydrocodone by utilizing drugs.com, which is a Schedule II controlled substance. Officer Saltzman read Rose her chemical test rights, and she agreed to a blood test. Rose was transported to the Henry Ford Wyandotte Hospital, where RN Nicholas Travis removed 2 vials of blood from her right arm. The vials were sealed and later placed in the outgoing mail to be mailed to the Michigan State Police Forensic Laboratories. Rose was transported back to the Wyandotte Police Station, where she was housed. After checking Rose through lean, it revealed that she had 2 prior OWI convictions. The first back in July of 2008 out of Southgate, and the second back in October of 2010 out of Woodhaven. A MAPS report was produced and it revealed that Rose had a prescription for hydrocodone back in May of 2025.
On examination of the complaining witness, I find that the offenses charged were committed. There's probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you. And ma'am, your name for the record, please.
Michael Rose.
Okay. And counsel, as to the arraignment.
As the arraignment, we waive formal reading. My client stands mute.
The court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. And you did in fact have an opportunity to speak to an attorney today. Is that correct?
Yes.
The court has also signed the petition to order for appointed attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th. 10:45 a.m. Counsel as to bond.
Your Honor, I know that my client does have 2 priors, but I will note that they're both 15 years plus old. She's not on probation or parole. She lives in Lincoln Park with her daughter, who's 24, strong family support system. She works full-time in a nonprofit organization. Your Honor, I believe that this is obviously something that potentially stemmed from a breakup that went terribly wrong, but I don't believe this is inherent of a situation where she's going to duplicate this behavior. I don't believe that she's a flight risk. I would respectfully request any consideration, although it is a felony, that her 2 priors are significantly old, and the other one is regarding damage to property. I would ask consideration for a personal bond. Thank you, Judge.
All right, ma'am, where do you work?
I work for a nonprofit in Lincoln Park. It's a 501(c), the Downriver Alano Club. I also forgot to mention that I do crafts with my mom on the side as well. I didn't tell, I forgot to disclose that information.
Okay. And ma'am, if you were to test right now, what is in your system?
Only my prescription for my antidepressants, my anxiety meds that have been brought here and given to me by the officers.
Okay, and what do you do for the nonprofit, ma'am?
Counter help, help with events, cleaning, decorating, opening and making sure that the rooms are open for members.
And what is the use Alano or Alamo?
Alano, as it
Okay.
and as a no, sorry.
Okay, and that's an environment for individuals in recovery, correct?
Yes, it is. Something that, sorry,
And are you out on bond in any other jurisdiction?
no,
Have you ever failed to appear for court in any other matter?
ma'am. Mm-mm.
I'm sorry?
No, ma'am, I haven't.
All right.
I've appeared when told to be or, you know, scheduled.
All right, and you're not on probation or parole anywhere, are you?
No, ma'am.
All right, Detective, would you like to address bond?
Yes, Your Honor. On this case, she does have 3 felony charges. Yes, the OWIs are older, but the MVP that she just committed, damaging the gentleman's car, I'm looking at 15,000, 10%.
All right. And ma'am, how do you know Mr. Hasselback? Do you have any children in common?
No, we were actually dating. We hadn't broken up. We had been together. And he didn't answer. And
I would ask, Judge, they don't have any children together, and
Yeah.
they were in a relationship, or obviously there's going to be no contact provision, which I won't object to.
After review of the charges in this matter, review of Ms. Rose's criminal history, taking into account the nature of the charges and the allegations, and that there are 3 pending felonies, the court does not find a personal bond would be appropriate in this matter. The court does find that a bond of $20,000, 10% is appropriate. You are not to, these are the following bond conditions, ma'am. You're not to have any contact with David Hasselback or Jill Sotheby Paulino. That's phone contact, text message, email, social media, third party, anything of the like. You are also not to enter the premises at Mr. Hasselback's home, nor Ms. Sotheby Paulino's home. You're not to possess or consume any alcohol or drugs unless prescribed. You also, ma'am, are not even to be on the streets that they reside on. You don't reside in Wyandotte. You don't have any reason to be on those streets. You're not to possess or have access to firearms or weapons. Do you have any of those, ma'am?
No.
You are not to be released without GPS and alcohol tether through the Wayne County Jail. Any questions?
No.
Okay, we'll see you back on March 5th. Thank you.
Thank you, Judge.
You can go in there and you can come over here.
Four? This lady has 4?
Yeah, she had warrants on 3 and then.
Okay. All right, let's go on the record in the matters of, let's see, we have the City of Wyandotte versus Cheryl Shabani, 1829227. 193794. The State of Michigan versus Cheryl Shabani, 241258. And the City of Wyandotte versus Cheryl Shabani, 26208. Okay, counsel?
Good morning, Your Honor. Christopher Shempke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Ma'am, your name for the record, please.
Cheryl Shabani.
All right, council, as the city of Wyandotte matters, which there are 3 of those, I'm actually running out of room on here with all of these files. With the city of Wyandotte matters, council, let's handle those as far as an arraignment. As the arraignment on those matters, council.
I'm waiting for formal reading. My client stands mute.
Okay, the court will waive the formal reading on those matters. Enter pleas of not guilty on your client's behalf. Schedule these matters for pretrial on March 4th, 10:45 a.m.
Like that one.
And then counsel, as to the state matter.
We waive formal reading. My client stands mute.
All right, ma'am, the court's going to waive the formal reading in that matter. You do understand you do have the right to have an attorney. And if you're unable to afford an attorney, you may have one appointed to represent you. Do you understand that, ma'am?
Yes, ma'am.
You have in fact had an opportunity to speak to an attorney today. Is that correct?
Yes, I did just before this.
The court is also signing the petition order for appointed attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, ma'am.
The court will enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th at 10:45 a.m. also.
It's 2 days right next to each other.
What's that, ma'am?
Nothing.
Okay, counsel, as to bond.
Your Honor, on a positive note, my client is a local resident of Lincoln Park, currently lives alone, but she is gainfully employed. She works at Getwell Urgent Care in Southgate. She's a medical assistant. She's also a full-time student at Henry Ford, taking 13 credits, and she has aspirations to go to nursing school. Judge, I know that there's some outstanding warrants. We'd ask that those be set aside, and we'd ask any leniency with determining an appropriate bond based on her age, her employment, and her schooling. Thank you, Judge.
All right, ma'am, why do you continue to ghost the court here? Do you not like to come visit here?
The last court date I did come to, the first one, apparently I thought it was a video on my phone, but it wasn't, it was here. But then my attorney rescheduled that next one. And then when I showed up to that one, I sat there for 2.5 hours on the video one. My attorney never showed up. And then I was told to hang up and get a hold of her. I got a hold of her. She never got a hold of me back. Now that's not me. I should have called again. I should have rescheduled.
Well, of course, ma'am, because it's been 16 months. So actually almost 18 months. So yes, well, first of all, you were arraigned out county on your felony matter September 1st of 24. You were scheduled for probable cause conference September 12th. You did not show up. A warrant was issued for your arrest. Prior to the court issuing the warrant, you must have contacted in and we rescheduled it to September 26th.
Yeah.
You were present. Your attorney was not. Your
Yes,
attorney,
ma'am.
the court made a note on here that you were present, but not at the time the case was called. Defense attorney attempted contact to no avail. The court waited an additional 2 hours to call the case so that your attorney could get a hold of you. And he or she was unable, Sarah Krause, she was unable to get in touch with you. And so the court issued an immediate warrant. Now, it's important to note that your charge in this matter is possession of controlled substance and driving a license suspended, revoked, or denied. That's important, ma'am, because not only did you fail to appear on 2 other matters for the same charge of driving a license suspended, revoked, or denied, but then you ended up arrested last night for the exact same thing once again.
Yes,
And
ma'am.
you have made 0 attempt to contact into the court to schedule any court dates. Because you also, ma'am, on your 2019 and 2018 cases also had failed to appear for your arraignment pretrials. We ended up sending you notice. We sent it for October 30th of 24. And you once again failed to appear in court on October 30th of 2024. You did not contact the court. You did zero, ma'am, to resolve your issues. Zero.
On the first ones, yes, ma'am, you're right. I didn't. I was very immature. Even though I was an adult, but I was very immature and stupid. I had a lot of drug problems. I've been trying to work through that stuff now. I haven't used drugs in a very, very long time now. I'm trying to get a better education. And that last one we got before this one with the drugs, I want to fight that one. And I was trying to fight it. And I'm sorry I didn't push it further and keep trying my lawyer. I want to take care of this and get this out of the way. I don't want this to happen more.
Ma'am, I can appreciate and commend you for being in recovery. However, what I'm hearing from you is you want to take care of these matters, but you're not doing anything to take care of them. In fact, excuse me, you're continuing to violate the law and driving without a valid license, as you're alleged in all 4 cases to continue to be doing.
I lost my license for the driver's responsibility fee. I didn't even know that was a thing until after I lost my license. So yes, I got upset. Wasn't fair. I lose my license for something I didn't even know about.
Well, ma'am, then you have to address it. You have to, excuse me, you need to address it and you need to stop driving until it's addressed.
Yes, ma'am.
And you reside by yourself?
Yes, ma'am.
All right, and you knew that you had warrants, and you knew your license was suspended, and you continued to drive anyway.
Yes, ma'am.
The court's going to, on the 24 matter, the court's going to order a $10,000, 10% bond. Based upon your previous failures to appear, the matter, you have 3 matters that you failed to appear on, and then you have a new matter that's the same charge as the other 3 matters.
That's 4 or 5 of them.
And the court will note that you have not made any attempt to resolve these matters since September of 24. The court's going to order on the 26th case a $10,000, 10% bond. The court wants to ensure the safety of the public as well, because you continue to operate a motor vehicle without a valid license, which does put the community at risk. On the 193794, the court's going to order a $5,000, 10% bond. And on the 182927, the court's going to order a $5,000, 10% bond. Your bond conditions, ma'am, are that you're not to possess or consume any alcohol or drugs that are not prescribed, and that you are to not operate a motor vehicle without a valid driver's license, which you're not allowed to do anyway, ma'am. But if you have posted bond and you are out and about and you're driving a motor vehicle, ma'am, you will be arrested again, and the court will likely revoke bond. And you'll be in custody until your next court date.
Understood, ma'am.
Have a good day.
Thank you, Your Honor.
All right, off the record. Okay, so I have one bond submission sheet that needs 4 copies.
So while we wait for the next contestant there, I want to show you Clayton County. This is paused. Where justice is best served in a hallway. That's a very crowded hallway this morning. And as far back as I can see, it's all females. So they had quite the party over there, apparently, last night in Clayton County. Anywho, Doesn't look like Judge DeSanto has anybody new yet. I don't want to go to dungeon court quite yet. So let's go back to Judge Elmore. He's got a fresh contestant.
Conference.
Your Honor, may I?
Mr. Dodge, did you have an, oh, no, I got it. All right, so we're here today for a final pre-trial conference. We conducted that in chambers, myself and counsel. They informed me that today there will be a resolution in the case. Mr. Carnes, why don't you go ahead and state the details for this pre-trial agreement today?
Yes, Your Honor, thank you. It's my understanding that the defendant will be entering a no contest plea to an added charge of assault with intent to commit penetration. That is a 10-year felony. People will be dismissing the charged CSC in the 3rd degree. There is also a Killebrew agreement that the defendant will be placed on a delay of sentence of up to 1 year. During the period of that delay, he will participate in the youth sex offender treatment program in Kent County, or rather in counseling under that program. That is abbreviated YSOTP. And if he completes that program or is still compliant with him at the close of the delay, then he'd be permitted to withdraw the plea to this charge and enter a no contest plea to criminal sexual conduct in the 4th degree. There's a further Killebrew agreement that there would be no additional upfront jail at the time of sentencing.
All right, thank you. Mr. Dodge, is that a complete and accurate statement of the pre-trial agreement between the parties?
Yes, it is, Your Honor.
All right, thank you. All right, Mr. Johnson, is that how you wish to resolve today's case?
Yes, sir.
Please raise your right hand. Swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may go ahead and take your seat. Make sure that when we're talking today that you answer loudly enough so that Nancy in front can hear you and I can hear you, okay? She needs to be able to take down every word you say. Looking back at a date range of September 1st to December 31st, back in 2024, were you on probation, parole at that time? All right, were you on bond pending any felony charges anywhere else?
No.
Thank you. All right, Mr. Johnson, you were currently charged on a felony information, which is just simply a piece of paper, and you were charged there with a single count. That single count is a charge of criminal sexual conduct in the 3rd degree upon a person aged between 13 and 15 years old. Now, that is a felony that is punishable by 15 years and requires mandatory AIDS and STD testing and DNA taken upon arrest. Plus, it is a Tier 3 Sex Offender Registration Act case, which would require sex offender registration to be conducted throughout the rest of your lifetime. And they are done, I can't remember if they're annually? Nope, they're done quarterly. Anyways. Also, you can be subject to periods of probation as well, right? You understand that so far?
Yes.
Now, I'm told today that you're going to enter a plea of no contest to another charge. Let's talk about what a no contest means. Typically, at a guilty plea, I have to have the defendant answer a bunch of questions to explain why he or she is guilty of that offense. So they have to tell me what it is that they did. Now, a no contest plea is slightly different. Instead of requiring the defendant to make a statement, I'm going to look at something else, such as a police report, or in this case, the preliminary examination transcript. I can only take a no contest plea in a couple situations. One is potential civil liability. In other words, the person could be sued. And from what the attorneys have told me, that's the theory that we're using with today. And I see both counsel shaking their head yes. All right. While a no contest plea has largely the same impact as a guilty plea, we're going to talk about that. If you enter a no contest plea and I accept that plea, you would not have a trial. Does that make sense, sir?
Yes.
Now, that means you would also be given up certain rights that you would have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, and the right to not have a trial suits against you. Do you understand those rights?
Yes.
Now, actually, I know you probably have heard them already because your counsel handed me a form that at the top says advice of rights, and then it appears to have your signature. I'm holding it up. Is that your signature at the bottom? All right. So did you read through all this information?
Yes.
And even though I also just went over it with you, did you understand what you read?
Yes.
And again, even more importantly, you understand that by pleading no contest, if I accept that plea, you will be forever waiving these rights as they apply to this particular case.
Yes.
So now we're going to talk a little bit more about that pretrial agreement. I told you what you're charged with, but I didn't go over what you're going to plead no contest to. Sorry, I just ended in a preposition. I haven't gone over to what you will be pleading to. So I'm told today you're going to plead no contest to an added count 2. And if I accept that plea, count 1 will be dismissed. Now that added count 2 is a charge we call assault with intent to commit a criminal sexual penetration. Now that is a felony punishable by, instead of 15 years, up to 10 years. Also required sex offender registration for life, and it's done, I think, quarterly for that offense. Now, even though you might say 15 years to 10, does it seem like a whole lot? Well, it actually also goes down on what's called Michigan sentencing guidelines. It goes from a B grade offense to a D grade offense. It also impacts potential sentencing. Now, I'm told that there's another portion of this agreement. It's probably the most important for you. The agreement is that I would place you on what's called a delay of sentence. A delay of sentence allows me to basically not finalize the case, not finalize the sentence. Imagine if the sentence means when I whack this piece of marble with a gavel. Well, I don't do that yet. I basically hold the gavel and put it off to the side and bring you back in about a year. And over that year, you're not on probation, but you have terms that are very similar to probation. That may include no contact orders. It may include no alcohol, drug testing, things like that, and also that you can't violate the law. Well, one of the terms or conditions that would be a part of this is that you would be ordered to remain compliant with this YSOTP program down in Kent County, which, as I understand, stands for something to the effect of Youthful Sex Offender Training Program. That's what the T stands for. And if you are compliant with your terms and conditions of that period of deferral or delay, then you would have the right to withdraw your plea to the count 2 that I've talked about, that 10-year felony, and instead enter a plea of no contest to another charge called criminal sexual conduct in the 4th degree. Now that is a high court misdemeanor punishable by up to 2 years and or up to $2,000. And additionally, there's sex offender registration requirements as well, but they're a lot less. There, it would be biannual registration done for a period of 25 years. And it's what we call a tier 2 registration versus a tier 3, which is the most serious. All right, do you understand all that? All right, let's talk a little bit about what that sentence means, or that agreement means. We call it a Killebrew agreement. Killebrew is just the name of an appellate case here in the state of Michigan. And what it says is that you and the prosecutor, along with your attorney, of course, have reached an agreement. And if at the time of sentencing I don't go along with it, you would have the right to withdraw your plea. You might be sitting there thinking, well, it sounds like the judge is going to go along with it. There's probably a pretty good chance I will. But I don't know anything about you. Now, why I'm told that you don't really have any prior criminal history and you don't look old enough to have any significant criminal history. Sometimes, I don't know, you might actually be wanted for some case across the world. Maybe you've been running drugs and it's across Gulf of whatever it's called now. But that's why I don't make that decision. But I really want to see how you find out more information about you. So if I don't go along with it, you can withdraw your plea. If I do go along with it, then we're going to continue to go along this program that I just got over with you. You understand?
Yes.
All right. Now, earlier I went over your rights with you, and then one more thing. Have there been any other promises, threats, or inducements of force or compel you to make this plea today that we haven't talked about?
No.
Okay. I also like to cover here with Mr. Carnes. Mr. Carnes, you've gone over the terms and conditions of this pretrial agreement with the plaintiff, I'm sorry, the complainant and her mother.
Yes, Your Honor, that's
Um,
correct.
And as I understand it, they are aware of it, the terms, and are in support of the resolution. Is that correct?
That's correct.
All right, thank you. All right, so Mr. Johnson also has as you've probably talked to your attorney, he's probably giving you all kinds of information about sentencing guidelines and potential sentencings and things like that. Has he made any promise to you as to what exactly I will do?
No.
You've been able to speak with Mr. Dodge about this case and the charges, and you've looked at the police report and transcripts. Is that right?
Yes.
Okay, good. And you've gone to him and he's been able to answer all your questions for you?
Yes.
And are you satisfied with his counsel?
Yes.
And you believe that his advice in this resolution today is in your best interest?
Yes.
So I'm now going to ask for your plea. Now, I'm going to tell you what I expect you to say. It doesn't mean that you have to say it. But if I don't give you this warning, everybody in that chair says the wrong thing. So I expect when I ask you what your plea is, there'll be no contest, right? So don't say guilty. So as to added count 2, assault with intent to commit to sexual penetration, how do you plead? All right, before the court can accept that no contest plea, I need to take a look at some information. And as the counsel advised me in chambers, we're going to enter as the basis People's Exhibit number 1, which I have in my hands. This is the preliminary examination transcript. The prelim was held on August 18th of 2025 before the Honorable Court of Wiggins of the 84th District Court. Mr. Carnes, are you asking the court to accept this exhibit for the basis of the plea?
Yes, Your Honor.
And Mr. Dodge, does the defense so stipulate for its use for the plea and plea and sentencing?
Yes, Your Honor.
People's Exhibit number 1 is hereby admitted. I did look through that. It's not all that long. I did read it in chambers before coming out today. Mr. Carnes, do you believe the interest of justice do not require the defendant to recite a factual basis?
Yes, for potential civil liability, Your Honor. Thank you.
And do you believe that the contents of People's Exhibit 1 satisfy the elements for the added count 2?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements today?
No, Your Honor.
And do you believe the court complies with Mission Rule 6.302?
Yes, Your Honor.
Mr. Dodge, do you agree with all what he said?
Yes, Your Honor.
All right, all right, good, thank you. Well, the court agrees that the interest of justice based upon what the parties have told me is really non-existent prior criminal history, the facts of the case, and what I've read in here. Again, the interest of justice do not require the defendant to recite a factual basis. The court also finds the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds that the information contained in the report again satisfies the elements for the added count 2. Therefore, the defendant is found guilty of added count 2, assault with intent to commit a criminal sexual penetration. Mr. Johnson, what's going to happen next is you're going to leave this courtroom and go downstairs to the probation and parole office, also known as the Michigan Department of Corrections. Now, I think you have a tether, right?
Yes.
So you got that at the office called the Community Corrections Office downstairs. No? Where'd you get it?
Through Manistee.
Oh, okay.
The GPS applies to this account.
All right. Well, Oh, was there another case in Manistee? That's right. I recall that from a few months ago. All right. So when you leave my court, or sorry, I should never say my court. People's Court. Then I said the People's Court, and it sounds like it's a TV show. You're gonna go down the elevator, take it all the way down to the ground floor. When you step out, do a sharp button hook to the right. At the end of that hallway is a door. Go through the door. It always sounds like I'm talking about a Dungeons and Dragons. Go through the door, but go through it. At the end of the hallway on your left-hand side is the probation and parole office, also called the Michigan Department of Corrections. When you go in that hallway, there's only 3 windows. If you ask anybody, hey, where do I go from Judge Elmore's court? They'll tell you, okay? Now they're gonna give you a packet of information. You're gonna complete that packet, and then you're gonna turn it in. You'll also be subject to an interview. That interview will be with an agent from that office. You have the right to have Mr. Dodge present during that interview. Now, this report that they're gonna prepare will talk about the pretrial agreement, what you were charged with, what you pled to, information about any prior criminal history you do or don't have. It'll also include the information that you provide while you're reporting this information to them. It could include a statement from any victim in the case. It will also include something called the scoring of the Michigan sentencing guidelines. Now, these Michigan sentencing guidelines are not mandatory. They just give the court a tool to help establish a reasonable and proportionate sentence. I just noticed there's one issue that I failed to cover in the pretrial agreement, but I'll get it in just a second, in case you're looking it up. All right. It will also include a recommendation as to what they think the court should do. Please keep in mind, it is strictly a recommendation. Nothing in there is mandatory. I alone get to make that decision. Understand, Mr. Johnson?
Yes.
So you're gonna leave here, go down there, get a packet, fill it out, turn it back in, schedule an interview, and then Mr. Dodge is gonna have to meet with you prior to coming back to this court, because he'll get a copy of that report, and the two of you need to go over it before I give a sentence or decide what to do. The reason is each side can come back and say, hey, Judge, this is wrong. This name is spelled incorrectly. This year is incorrect or whatever. Okay. Now, the one thing I forgot was one of the terms or conditions of this killover agreement is after, if you're successful with that delay period and you withdraw your plea and then we enter a plea to the reduced charge of CSC 4, there was also a term in the agreement that there wouldn't be any additional initial jail. Additional means obviously you get credit for any time you served in jail, so I give you that credit, but you wouldn't have to serve any initial additional jail. That means that if I'll put you on probation, if you violate probation, then I can give you jail. Okay, does that make sense?
Yes.
Do you still wish to go proceed with the plea?
Yes.
All right, the court reaffirms its findings. Anything else today, Mr. Carnes?
Your Honor, Mr. Johnson and I were discussing, he wanted to bring a bond motion, and I think we've reached an agreement whereby Mr. Johnson has a radius, and I think it's fair to reduce that radius to 1 mile to the victim's house and school. He's prohibited from going within 1 mile of both locations. I think it's bigger than that right now. I have no objection to reducing it to 1 mile.
Is that correct, Mr. Dodge?
Yes, it's been a little bit of a gray area on what the radius is, but I think we agree with mile.
The court will modify the terms and conditions of the bond that the GPS radius will be 1 mile from the victim's residence. Mr. Carnes, hold on.
Oh, yeah, and her school.
And her school. And that school is?
I'm pretty sure it's Mesick High School.
All right, Mesick High School, and then I'm not going to state her address on the record out loud here, but if you would please make sure that clerk has it. Let me take a quick look. Maybe it's on it. I don't see it listed on the Register of Actions, so just make sure Madam Clerk has that address.
Yes, Your Honor.
All right, thank you very much. Anything else, Mr. Dodge?
No, thank you very much, Your Honor.
Good. Otherwise, all your bond conditions remain in effect. Mr. Johnson, don't forget, go straight downstairs, button hook to the right, walk straight. Thank you. We're adjourned. Yep.
Okie dokie. First things first, Great Granny, congratulations on your bingo. So for those of you who are watching who aren't familiar, we here at TCF created a bingo game for you to play along as you watch court. It's based upon the things that you see as you're watching. You can find that at tcfbingo.com, and that's available every day that we're live, so you want to check that out. Okay, so this defendant and the YSOTP program. One of the things I found interesting is this is a Kent County program, but this defendant is being sentenced in Wexford County. So apparently there's some county cooperation going on there now. But one program, and I grew up in West Michigan. I lived in Kent County for several years, so I'm very familiar with the area. And it's a very conservative area, and they tend to punish hard there. So this is interesting to me, but I was aware of a program called ASOTP because that's been around for about 30 years now. But it's morphed into this YSOTP. The ASOTP was an adolescent sex offender treatment program, which dealt with kids under 18. But it's morphed into this YSOTP, which deals with people aged 17 to 24. It began taking participants in the fall of 2018. The program is offered to individuals between 17 and 24, as I just said, who have committed a non-violent sexual offense. So think like a 22-year-old getting with a willing 16-year-old. So not a violent situation, but still against the law. The YSOTP program is designed much like ASOTP was to hold the individual legally accountable for their conduct and to focus on rehabilitation. Upon successful completion of the program, the individual may be offered a change of plea from their original charge to a different charge to permit them to avoid the harsh impacts of SORA. That's the Sex Offender Register Act. Talks about a grant. We don't care about that. Here are the highlights of the program. Either the prosecutor or the defense attorney identifies that the case appears to be one eligible for entry into the program. The prosecutor will conduct a review of the case to determine if his office will approve the case for psychological assessment. Step 2, psychologists from either the Men's Resource Center or Psychological Services will conduct an extensive assessment of the candidate utilizing interviews, collateral data, and a number of testing devices to determine if the individual is an appropriate candidate for the program. The assessment will balance the relative risks and amenability to counseling and whether the individual will ultimately benefit from the participation in the program. Attorneys receive a copy of the assessment report, and the matter is scheduled for a review. At the review meeting, the candidate and their screening results are shared and discussed with the team, and it is decided whether to approve the candidate for the program. If approved entry into YSOTP, the participant will enter a plea to an agreed-upon criminal charge and be given a delayed sentence to reappear within 10 to 11 months for sentencing, which is what we just saw happen. Upon successful completion of YSOTP, the individual will reappear for a change of plea to an offense that may not require registration to SORA. If the participant does not successfully complete the program, they may be discharged and have to register on SORA and be subject to additional court sanctions, including jail or prison. So that is what's happening there. It seems to be an intervention program designed for younger people who were not violent but still broke the law in such matters. It's interesting to me that it comes out of Kent County because, again, Kent County is very conservative and very aggressive with their sentencing traditionally. So, interesting, but that's what it is, and that's what he's been put into. So now we all know the rest of the story, as Paul Harvey used to say. Ladies and gentlemen, it's that time for our Friday guilty pleasure. The floors carpeted with shining crimson, lighting from the Cold War, very Soviet looking. Walls where you can tell it's bleeding blood. The souls of the damned can be heard from behind. The printer never stops running. The judge never stops get angry. Justice best served in a cold, dank basement room. This is how justice is properly done in Appalachia. I give you dungeon court.
I turned my community hours in, they said they needed to check on it. I did with the compound.
That was turned in this morning, Your Honor.
Yes.
Okay. Where did you do the dip school?
Lawrence County Recovery.
Did they give you something, or I don't have anything in the file on that? Usually they would turn it in.
She just said it was turned in over there at the office there. I went in there to check on it today. No, I went there. She said she has everything for it. That's what she just told me.
The clerk did?
Yes.
Okay, well, it's not in the file. Let me see. Well, here's what I'm going to do. We'll just need to verify that and it gets filed. You got something?
This is what she just gave me. Over told me that the school was. She said that's all I had left was that, and I turned it in to you.
This is receipt, Your Honor.
Yeah, that's all she gave me.
Well, I have to have a report from the driver intervention program that you finished it.
Yeah.
And usually they follow it, so I don't have it right now. So what I'm going to do, I'll give you another day. As long as that gets filed, you don't have to come back. So
Okay.
you should check on it, make sure it
Yes.
gets filed. So let's, I'll go into April. I'll set it for April the 6th. Hopefully you won't be here because everything will check out.
Yeah, I won't be here.
April the 6th, 9 o'clock.
All right, thank you, sir.
You're welcome. Caitlin Allman,
Yes, sir.
25,500 is the case number.
Yes.
Change to your community service, you just have to pay on your fines. Can you
Yes.
pay anything on your fines today?
No, but I will have them paid off in the next 2 weeks, like everything.
Okay. I'll set you the same time because this was your first hearing today. So April the 6th, if you get it completed and paid off, you don't have to come in.
Okay, thank
9
you.
o'clock on April 6th.
All right, thank you.
You're welcome. William Baker, 24,332 this year. Got a report from RRS. Okay, it's a good report. You've done everything to complete that, so I'll go out a couple months to see if we can get that wrapped up. So let's make it exactly 2 months. April 20th will be the next hearing. 9 o'clock.
Thank you, Your Honor.
You're welcome. Stephen Herman. Your Honor, if I may, he called in yesterday. He owes 10 hours of community service, I believe. Correct. His mom is in hospice, and they gave her last night to make it. Okay. I told him I would advise you, and that he has 7 days before we won't issue. Okay, well, what I'll do, do we have contact information for him, or? I believe I do. Okay. I'll just continue it for 2 weeks under the circumstances. And then. He advised me he would be here Friday. Okay, well, if he gets it done, he doesn't have to come back. Otherwise, he's going to be here on March the 6th. Yes, sir. March the 6th is his next hearing at 9 o'clock. Thomas Farnsworth, 13-1005, is here. He has been adjusted for today.
Yes.
Still there?
Yeah.
Okay, got a report from them. Okay, it's a very good report. You
You still have some fines and community service to do. Are you going to be able to do that?
Yeah, what do I do, mate?
Are you living in Ironton?
Yeah, 650, yeah.
Okay, you can do it. Ironton Municipal Court's a lot closer for you than to come here. So if you want to go there, they have a community service program, do it there, just tell them to send the hours here, we'll accept.
Okay, how many hours do I have?
30 hours. That's what you got left. Plus you got $385 in fines and costs.
Okay.
Did you pay anything on those today?
No, I didn't, I just now heard about this.
Okay, what's in your judgment entry? I'll set your next hearing. March 27th. March 27th will be your next hearing, 9 o'clock.
Okay, thank you.
You're welcome. Cynthia Gaming, 25,537. Got a certificate of completion from Phoenix Center. Is this mine to keep these documents? Okay. So you still have your community service and fines to do too, so
Yeah.
can you pay anything today?
Yeah.
How much are you gonna pay?
I think it's a $50 fine. I don't know. I'm gonna ask.
Okay. Well, give me a figure. What do you think you can pay? 'Cause I'll put that on the file.
What can we pay? I'll pay the full fine.
Okay, I'll put you down for 50. Go see the clerk and make that payment. And then your next hearing will be March 20th, 3/20. 9 o'clock, see the clerk. And get your community service done too. You got 5 days community service.
Can I also do that out of Ironton?
You can.
Okay, and just have them send it here.
Just tell them that you're doing it for our court. They'll accept it and send the hours up here.
Okay. Thank you.
You're welcome. Charles Hawley. Charles Hawley is case numbers 25-368, 25-377, 25-383 has not appeared, so there'll be a warrant for failure here.
Jason Morrow, Adam Reimer, Tommy Scarberry, Savon Stallworth, Jason Tackett, Stephen Vickers, Tyler Young.
I was the first one that called. I just couldn't get through the door. Just fast.
Jason Morrow. Jason Morrow is here, 25-330. Okay, you are supposed to be going to some counseling and pay restitution and a fine.
I'm in counseling at Huntington Behavioral Health.
Do you have anything from them verifying that?
No, I can get it Tuesday. I go see my counselor.
Okay, you need to bring me something back the next time. Are you paying anything on your fine and restitution?
Not today. I'm battling with disability and I've been fighting some medical troubles, and then we lost my niece there traveling back and forth to Columbus, so.
Okay, I'm gonna set your next hearing for March 16th, 9 o'clock. Bring me some verification of your counseling then.
Okay.
And make a payment. You got, the restitution goes to a third party, so that doesn't go to court, that needs to be paid.
Yes, sir.
Adam Reimer, 22-327. Adam Reimer is not here. Oh, you are here? Okay,
Yes, sir.
Adam Reimer is here, okay.
We've done that too many times.
Do you have anything you're paying on your fines?
Yeah, 20 today, sir.
How much?
20.
Okay, you gotta get out here and get some community service. Give me a date when you can be here.
Yes, I called them last week, and then today I went in there and talked to, I'm in Portsmouth, so they're gonna let me go to that courthouse. And I completed treatment yesterday, so.
Do you have anything on that? You read surrender?
They didn't fax you guys nothing, or? I think they sent progress stuff, that's what
I did have a report from them, it was in January.
all right, I'll get you one today. I'll get it faxed to you.
Okay, see the clerk to make your payment. Your next hearing is March 20th.
March 20th, thanks.
9 o'clock, March 20th. Tommy Scarberry is here, 2473. He's been at OVP. We got a report from them saying he's continued there and making progress, so that's good. Service all done. You just have to finish your counseling and pay your fines. Do you have a payment today on your fine?
On the 6th.
Not today, I have on the 6th.
Okay, March the 16th will be your next hearing, 9 o'clock. Continue with your counseling at OVP.
Okay.
Savon Stallworth, 23,859, Savon Stallworth.
Your Honor, if I may, he called in this morning, said he was going up here by Zoom. He did turn his community service in. I do have to verify that.
Okay. I'll put it aside because it doesn't look like he's on there now. Is Stallworth on teleconference? Okay, not yet. Nobody's answering, so we'll call him back later. Jason Tackett is here, and you are paying on fines. Do you have a payment?
Yes, 50.
Okay. Go see the clerk. Make your payment. And I'll set you for March 20th.
Thank you, Your Honor.
You're welcome. Stephen Vickers, 2414. Community service all done and most of your fines paid. You just have a little bit left. Do you have a payment today?
No, I don't try to do community service, I just haven't been able to.
Your Honor, if I may, I have a note. Mr. Vickers was ordered on January 16th to be here for community service on January 17th.
On the 16th, I told him I was gonna try. I plan on coming tomorrow. I've been sitting with my nephew
Okay.
that has muscle dystrophy and he has to
You need to hold on, so. Placing you in custody. Tyler Young, 25502. You're not Tyler? Okay, what's your name, sir?
Joseph Agnew, that was the first one you called, I just couldn't get that.
Okay, we'll come back to it. Tyler Young's been called, did not appear, so there's some more failures here. Joseph Atkins is here, I'll mark one out. 23,356. Community service is done, you just have to pay off your fines. You did make a payment today. Okay. Next hearing, March the 20th.
Thank you.
9 o'clock, March 20th. Okay, that finishes the reviews. We're going to start the new cases. Anyone out in the hall that has a new case, they need to come in now. And if you got an old case that you missed a hearing on, you're going to get called. As long as you check in with the clerk. If you missed a hearing before, you need to go check in with the clerk, so we'll put you on the docket. When your name's called, come up to the table to your right, stand there. I'm going to go over the charges with you. You have a right to remain silent. You don't have to say anything, but if you do make statements, whatever we say in the courtroom is on the record. It can be used against you if you admit something. If you got stuff you want to talk about and questions, you need to get a lawyer, and then what you say to the lawyer is privilege. It can't be used against you. What you say in open court is fair game for the prosecutor to use against you. So, less said, the better at the arraignment. You have a right to have bail, to have a lawyer appointed if you can't afford one, to make the state prove the charge against you beyond reasonable doubt. Those are the rights you have as defendants. If you enter guilty or no contest, you're waiving those rights. You should not do that if you don't understand what's happening. If you're confused, if you don't know what to do. If you do want a lawyer in a trial, enter a not guilty plea. That's the safest plea you can always enter. Call the first case.
State of Ohio versus Rebecca Boyles. Case number PRC 26265, A, B, and C.
Okay, Ms. Boyles, you are Rebecca Boyles?
Yes.
Ms. Boyles, it's alleged on February the 14th at 2:20 a.m. in Perry Township, you were driving a vehicle while you were under the influence of alcohol. The state's alleging that you took a breath test and tested 15 on a breath test. It is alleged to be it would be your first conviction if you get convicted. On a first offense under Ohio law, the maximum you face is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most the court can impose on a guilty finding. There is a minimum, so the least you can get if you're found guilty is 3 days in a treatment program, $375 fine, 6-month license suspension. That's the minimum penalty for a guilty on an OB, we call it OBI. The test score of 15, there's what's called a per se level under Ohio law. It's 8. So what that means, if the state can show a valid test, there's rules about giving the test, the breath test. They have to show they comply with those rules. If they can do that, there can be a presumption of impairment by any test score 8 or higher. They're saying 15, which is obviously higher than 8. Do you understand that charge and the different things I explained about the breath test? And
Yes.
Then you've got two other charges. Driving outside your lane, that's a minor misdemeanor. There's no jail time on that. Maximum penalty is going to be $1 fine. And then it says a C case. Let's see what that is. Oh, speeding. They are alleging you were driving 84 miles an hour in a 55 zone. So that's a minor misdemeanor. Maximum penalty is $150 fine. So you've got 3 charges. Do you understand the 3 charges?
Yes.
What plea do you wish to enter?
Guilty.
Guilty means you're admitting the charges are true. By doing that, you waive the right to have a trial, have a lawyer, and to make the state prove these charges beyond a reasonable doubt. Do you understand that?
Yes.
Okay, I'm going to accept your guilty plea. I'm going to read the report of the officer into the record. Then if you want to make a statement, you can. You don't have to, but you have the right to make a statement. You will hear what the officer says first in his report. This is Officer Jewell from the Ohio State Highway Patrol. And he writes, I was patrolling US 52 eastbound near milepost 17. I observed a station wagon going westbound at a high rate of speed. Checked the vehicle speed in the 70s and crossed the median to catch up. While catching up to the vehicle, I continued to monitor the speed between 69 to 84 miles an hour. While behind the vehicle, I observed it display improper lane positioning issues to include straddling the center line and driving on the right shoulder by approximately a foot and straddling the right fog line. I turned on my lights. The vehicle went to the center and then onto the right shoulder before signaling. I made a passenger side approach to the vehicle, and the driver was Rebecca Nicole Boyles. In the rear passenger seat was a drunk young male. When I reached the passenger compartment, Miss Boyles had bloodshot, watery eyes. Her eyes appeared red. She had a dazed look on her face. I detected an odor of alcohol coming from the passenger compartment. I informed Miss Boyles the reason for the stop and asked if there was a reason for her speed. She advised that she picked up the passenger from the arcade bar in Huntington, was trying to get him home as fast as possible because he'd been thrown out at the bar. Miss Boyles' speech was slightly slurred at times. I asked her to exit the vehicle and directed her to the passenger side of my patrol car. I noticed that she was uneasy on her feet. Once standing by my patrol car, continued to detect an odor of alcohol coming from her person. Asked if she knew how fast she was going. She said she was unaware of her speed. I noticed she had issues with fixating her eyes. And I asked her again how much she had to drink, and she reported I had a couple of drinks at the bar. I asked her if she would be willing to do tests, and she said she would. asked her if she had any recent head injuries, and she said she considered herself in good health and doesn't take any medications. Gave horizontal gaze in the seconds, that's the eye test for alcohol. There were 2 clues. Conducted a walk and turn test. I observed 5 validated clues during the walk and turn. 1 leg stand. I observed 3 valid clues. Administered a portable breath test, and it showed a test for 0.16. She placed under arrest, advised of Miranda rights. She had a vape pen containing cannabis in her pants pocket. She said someone gave it to her at the bar, and she admitted that it contained cannabis. There was baggies containing small pieces of cannabis in the vehicle. She was taken to the patrol post, agreed to give a breath test, and tested 156 on the breath test. Okay. Any statement or explanation you want to make?
No.
Okay.
No point.
Are you working? What do you do?
Yeah, I work.
I can go 2 ways on your drive. You got to get a driver's license suspension. It's required. I can give you limited driving privileges, and you just have to have proof of insurance. After a 15-day, there has to be a 15-day no driving time. And that's called a hard suspension. That I can give you limited driving privileges for like work and community service and those sort of things. I can give you unlimited driving privileges. But to do that, you have to have the device placed on your vehicle that you blow into to start, and you have to pay for that. And it's, I think, about $1,100. And you pay. It's not to the court. We don't keep them. There's a company that installs them out of Portsmouth. So, what are you interested in? You want the unlimited, or you want?
Can I do the limited, please?
Yes. Okay, that won't cost you any extra. Okay, on your. The way I do the fine, the higher you test on the test score, yours is relatively high, but it's not extremely high, I would say. It's well above the per se level. So I'm going to give you a $500 fine based on your test score. Order you to pay the court costs. I'll do a 6-month license suspension, and it started the day of the incident, the 14th. I'll give you limited driving privileges so you can drive to and from work. Is driving a part of your job?
No, it's not a part of it, but.
Okay. To and from work, to come to community service, which I'm going to give you, to go to the driver intervention program, which is thing you have to do, the 3-day school, you have to do that. You don't go to jail. Which I don't want you to go to jail. I'm going to give you a jail sentence, but I'm going to suspend it. And there's no reason for you to go to jail unless, as some people inexplicably do, blow things off and don't take care of business, then you have to go to the jailhouse then. So don't be one of those people that thinks nothing's going to happen if I don't do this. Something is going to happen, and it's going to be jail time. So there's no reason for you to go to jail. Take care of what you're supposed to do. 20 days in jail, suspended, 5 days of community service. We have a community service program here at the court where you can work any day but Sunday or a holiday. So what's your work schedule?
I'm usually off every other weekend. Do they do it on the weekends as well?
Saturdays.
Okay.
You can work any Saturday.
Okay. And I've got random days off throughout the week, so I'll do it.
7:30 a.m. here at the court, any day, but Sunday or a holiday. You can come do community service. You can report on the west side of the building. At 7:30 to be done by 2:30-ish. You'll have 2 years of probation, but I'll terminate it once you finish everything. So if you were here earlier, we had those review hearings. I'm going to give you 6 months to get everything done. You can get it done in that time frame. Those people didn't get their stuff done within 6 months, and then they have to start coming back to hearings for me to monitor what they're doing. Now, some of them are going to have more to do than you are doing. But here's how you can go to jail. Blow it off, don't do it, and don't come to your review hearing. You're gonna get a warrant and go to jail if you do that, so. And as I say, some people do that. Some people just don't, they think nothing's gonna happen, I guess, or don't think about it, and they wind up going to jail. Okay, your review hearing is gonna be September the 18th. September the 18th, so you got all spring and summer to get this done. On the speed offense, that's kind of bad. Somebody, 84, and not very smart. I mean, this is, 84 is what, at 2:20 in the morning on US 52, that's what I see young males doing. Because young males are not very bright. They think they're not. You mix testosterone and alcohol, and they think they're Superman. I guarantee you, if you come out 10 nights and run down 52 at 84 miles an hour, you're going to get pulled over every night. Every night you're going to get pulled over at 2:20 in the morning because they're looking for drunks.
Yeah, my passenger was also trying to like open the doors and jump out of the vehicle, and
Maybe you should have let him do it. Or call an Uber.
Yeah, call an Uber,
Ubers are
I
very
know.
cheap now compared to what this is going to cost you.
yeah,
You
you're not.
could get
yeah.
20 Ubers or 50 Ubers for what this is going to cost you.
Trust me, I know.
And it's going to affect you. I mean,
Yeah.
you're not going to be affected like a young male would because they're the highest risk. They think they're great drivers, but they're terrible drivers. Insurance goes way up. Yours is probably going to go up, well, not probably. Your insurance is going to go up now too. So eventually it'll come back down, but for a while, you're going to pay a higher insurance rate. Okay, on the speed, I'm going to give you the maximum fine because that's very unreasonable. 184 and a 55 at 2:20 in the morning after you've been drinking. Not smart and dangerous. So $150 fine. And then on the lane violation, I'll do a $30 fine. Okay, you're going to meet with the probation officer. His name is Mr. Major. He's to the left as you go out in the lobby, on that side of the building, the open counter. Go there, tell him who you are. He's going to pull up your paperwork, have you sign some stuff, then you're free to go.
Okay.
You look like you got a smartphone or a laptop, and probably both, right?
Yes.
Okay. There's no, and this would be a young male thing to do, is get arrested and come and say, oh, I lost my paperwork, that's why I didn't come to court. There's a website here at the court that you can put your name in, and it shows you when you've got to be back to court and what your charges are, and what, you know, there's no excuse, in other words. There's no excuse for not knowing what you need to do and when you need to do it. Okay? And it's not going to go away. All right, go see Mr. Major, and then you're free to go after that.
Thank you.
You're welcome.
A rare laughter in dungeon court. I can't say that I've ever heard laughter there. That's really weird. It kind of messes with the lore and the mystique of all of this, so I don't know how I feel about that. Oh well. Thanks for joining me today and joining me this week. It's been up, down, right, left, weird kind of week, but it's been fun, and there's no place I would rather be than spending my mornings with you guys, so thank you. And to that end, we'll be back on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member, and I look forward to seeing you then. In the meantime, go have yourselves a great weekend. Take care. God bless.